Chief Justice and this on the court, so that I recall the order. I finally recall order that matter is contempt and the petitioner filed in contempt. So that matter will be my lord, listed.
Please speak once again.
My lord, I finally recall order. My lord, which is Justice Chief Justice Court in this court. So that now the Chief Justice Court is not here. So that my lord and your lordship will had this matter. So that I finally recall.
That is to be assigned by Honorable Acting Chief Justice to maybe that he may take up the matter along with my esteemed brother. Why you are mentioning?
My lord, I filed in the DR, this Honorable Chief Justice Court was sent to DR, so that I DR in mentioned in DR court. But DR court said that you mention court.
No.
How can it? No. He can't say like this.
That
it is to place for the SCJ assignment will be.
But this SCJ court is not assigned. Any mention matter is not here.
You file it.
That he said that
you file it in DR will see. File it.
File the DR. The DR. Case number. No, don't keep the memo here. Just get the number and. Yes. Yes.
Weekly list item number 2.
Item 2, my lord. I got on order. It was listed on 3/11/2023. Thereafter, it was adjourned to 10/11/2023. But thereafter, my lord, as because the mother of Honorable Justice Kohli passed away, he was on leave, my lord. So recently, yesterday, he has joined. So the matter will be listed within the. November ପରେ ଆଉ ଡେଟ୍ ହେଇନି ନାଇଁ ସେ ଜଷ୍ଟିସ କୋଇଲିଙ୍କର ମଦର ଏକ୍ସପାୟାର କଲେ ସେ ଲିଭ୍ ରେ ଥିଲେ like we are granting him time anybody is appearing for the petitioners? One is none appears for the petitioners. Mr. Orupananda Das, an additional government advocate, produced the order dated 3/11/2023, passed by the Honorable Supreme Court in specially petition civil diary number so 38701 of 2023. From which it appears that the matter was directed to be listed on 10th November 2023. Mr. Das submitted that on 10th November 2023, the matter could not be listed and some more time may be granted to obtain instruction about the status of the SLP as per order dated 6/11/2023. Put up this matter, January, is this matter, second week of January. Data is taken on record for them or produce the order dated funds also. It's a list of all the like. नहीं तो मैं बाहर करी थोड़ी नहीं सिंगल बेंच और प्रथम रे थी वो डिवीजन बेंच नहीं की ओहो अच्छा हाँ और ब्रिक के स्टैंड है तो काट दी टेंशन नहीं yes that's all.
Item number 22.
May I please also?
We'll do it from the state side.
Well,
You will do it. Please.
yes, madam. Here is the offense under section 302. The appellant has been convicted for life imprisonment, my lord. And the cause of death is due to poisoning, my lord.
Come to the FIR.
Yes, my lord. May I kindly have a glance to running page 26, my lord. Relevant portion starts on paragraph page 828, my lord.
Yes, 22. 28, madam.
Item number,
Item 22. Yeah.
Item number 22, Mr.
No.
Yes, yes.
That's what JCRLA number 45 of 2008.
Madam.
Right?
Madam.
Fine, madam.
Hmm.
Okay. So he is pressing the FIR. Yes.
ମହେଶ ନିବେଦନର ଅଭିପ୍ରାୟ ଏଇକି ଯେ ଆମ୍ଭେ ପ୍ରାଣକୃଷ୍ଣ ମହାରଣା that is PW1 in the case. ପିତା ମଦନ ମୋହନ ମହାରଣା ପୁରୀ ଜିଲ୍ଲା ପୁରୀ ଜଣାଅଛୁ କି 26/5/2006 ଶୁକ୍ରବାର ଅପରାହ୍ନ 5 ଘଟିକା ସମୟରେ ମୋର କନିଷ୍ଠ ପୁତ୍ର ଶ୍ରୀ ଧନେଶ୍ୱର ମହାରଣା ଡିସିସ୍ ମେଲେ ଆମ୍ଭ ଗ୍ରାମରେ ଥିବା ତାର ମାମୁଁ ଘରେ କ୍ଷୀର ପିଇଥିଲା କିନ୍ତୁ କ୍ଷୀର ଏକ ଢୋକ ପିଇବା ପରେ ଉକ୍ତ କ୍ଷୀର ତାର ପାଟିକୁ ଅତ୍ୟନ୍ତ
ମାମୁଁ କିଏ?
Who is the
ମାମୁଁ?
ମାମୁଁ ଘରେ
ମାମୁଁ?
ପବନି ମାମୁଁ's name is Pabani, my lord.
He is not the accused.
He is not the accused. Son, ମାମୁଁର ପୁଅ ମାମୁଁ ପୁଅ ଭାଇ ହବ ଯେ ମାଲିକ.
Acha. This Prashant is the ମାମୁଁଙ୍କର ପୁଅ.
Yes.
Okay. So what is the name of the ମାମୁଁ?
ମାମୁଁ Pabani, my lord. Pabani has not been examined.
Not been examined.
Yes. But
it's all right.
Yes.
ପଢନ୍ତୁ.
ଆମ ଗ୍ରାମରେ ଥିବା ତାଙ୍କ ମାମୁଁ ଘରେ କ୍ଷୀର ପିଇଥିଲା କିନ୍ତୁ କ୍ଷୀର ଏକ ଢୋକା ପିଇବା ପରେ ଉକ୍ତ କ୍ଷୀର ତା ପାଟିକୁ ଅତ୍ୟନ୍ତ ପିତା ଲାଗିବାରୁ ସେ ତାର ଆଈକୁ କ୍ଷୀର ପିତା ଲାଗିବା ଜଣାଇଥିଲା କିଛି ସମୟ ଯିବା ପରେ ଧନେଶ୍ୱର ଘରକୁ ଆସି ତାର ସାର୍ଟ ଆଇରନ୍ କରିବା ସମୟରେ ଧନେଶ୍ୱର ଡିସିସ୍ଡ ତାର ସାର୍ଟ ଆଇରନ୍ କରିବା ସମୟରେ ତାର ବୋଉକୁ ଏସବୁ କଥା କହି ତଳେ ପଡି ଚିତ୍କାର କରିଥିଲା ତୁରନ୍ତ ତାକୁ ଆମ୍ଭେ ଅଟୋ ରିକ୍ସା ଭଡା କରି PW10 ମାଇଲ ତୁରନ୍ତ ତାକୁ ଆମ୍ଭେ ଅଟୋ ରିକ୍ସାରେ ଭଡା କରି ଚନ୍ଦନପୁର ଡାକ୍ତରଖାନାକୁ ନେଇଥିଲି ଚନ୍ଦନପୁର ଡାକ୍ତରଖାନାରେ ଡାକ୍ତର ରାକେଶ ସାହୁ he is the court witness ମାଇଲ CW ମାଇଲ he is the CW ମାଇଲ CW1
Okay, ଠିକ ଅଛି
ଡାକ୍ତର ରାକେଶ ସାହୁ ଏକ ଇଞ୍ଜେକ୍ସନ ଦେଇ ପୁରୀ ବଡ ଡାକ୍ତରଖାନାକୁ ପଠେଇ ଦେଇଥିଲେ ବାଟରେ ଯିବା ସମୟରେ ମୋର ପୁତ୍ର ଧନେଶ୍ୱର ମୃତ୍ୟୁ ହୋଇଥିଲା ପୁରୀ ବଡ ଡାକ୍ତରଖାନାରେ ପହଞ୍ଚିଲା ପରେ ଡାକ୍ତର ମୃତ୍ୟୁ ଘୋଷଣା କରି ପୁରୀ କୁମ୍ଭାରପଡା ଥାନା ଓ ଚନ୍ଦନପୁର ଥାନା ଏ ବିଷୟ ଜଣାଇଥିଲେ ତାରିଖ 27/5/2006 ତାରିଖରେ ଧନେଶ୍ୱର ପୋଷ୍ଟମର୍ଟମ ଚନ୍ଦନପୁର ପୁଲିସ UD 11/2006 କେସ୍ ଉପସ୍ଥିତିରେ କରିଯିବା ପରେ ଶବ ସତ୍କାର କରାଯାଇଥିଲା ତାରିଖ 30/5/2006 ରାତ 9 ଘଣ୍ଟିକା ସମୟରେ ଆମ୍ଭ ଗ୍ରାମବାସୀଙ୍କ ଉପସ୍ଥିତିରେ ପ୍ରଶାନ୍ତ କୁମାର ମହାରଣା ପ୍ରେସିଡେଣ୍ଟ ଆପେଲେଣ୍ଟ ଥାନା ଚନ୍ଦନପୁର ପ୍ରକାଶ କଲେ ଯେ ମୁଁ ସେ କ୍ଷୀରରେ ବିଷ ମିଶାଇଥିଲି ତେଣୁ ଧନେଶ୍ୱର ସେ ବିଷ କ୍ଷୀର ପିଇଥିବାରୁ ତାର ମୃତ୍ୟୁ ହେଲା ଏଇ କଥା ତାର ବାପା ପବନୀ ମହାରଣା ମୋର ସାନ ଭାଇ ମଣିଧର ମହାରଣା କୁ ଜଣାଇଥିଲା ମଣିଧର ମହାରଣା ନଟ୍ ଏକ୍ସାମିନ୍ଡ ଏଣୁ ପ୍ରଶାନ୍ତ କୁମାର ମହାରଣା କ୍ଷୀରରେ ବିଷ ମିଶାଇ ମୋର ପୁଅ ଧନେଶ୍ୱରକୁ ହତ୍ୟା କରିଅଛି।
ପବନୀ ମହାରଣା ଏକ୍ସାମିନ୍ ହେଇଛି।
ପବନ ମହାରଣା ଇଜ ନଟ୍ ଅଲସୋ ଏକ୍ସାମିନ୍।
Okay.
ଏଣୁ ବିନୀତ ପ୍ରାର୍ଥନା କରେ କି ଆପଣ ଉକ୍ତ ବିଷୟରେ ତଦନ୍ତ କରି ଦ୍ରୁତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗ୍ରହଣ କଲେ ଆମ୍ଭେ ବିଶେଷ ଉପକୃତ ହେବୁ।
So it is a case of circumstantial evidence.
Circumstantial evidence.
One is that he had gone to the house of his uncle,
Yes, my lord.
as it appears from
Yes.
the FIR.
Yes, my lord.
Number one, number two is the dying declaration before his mother.
No lying declaration there.
No, no, oral dying declaration.
Oral-
Who pakir pura koila
No,
ma
that is oral lying. Yes,
Yes.
ma'am. That is there.
PW10.
Yes.
So that's an important piece of, and then extrajudicial confession before the villagers,
Villagers.
right?
Yes, ma'am.
So these are the men. We'll see other.
Yes.
So you bet first come to the evidence of PW10.
Yes. PW10 at page, my lord.
Yes, yes. 72.
Yes, ma'am. 7. May I, ma'am?
Yes.
The accused in dock is my nephew, brother's son. My mother had adopted Pavani Maharana, the father of the accused, Dhaneswara Maharana.
Tikke check. Accused hela moro bhainkara puo. Okay, huh?
Yes.
My mother had adopted Pavani Maharana. Maharana is the father of the accused. ठीक है. पढ़ो.
Dhaneswara, may I start, ma'am?
Continue.
Dhaneswar Maharana, the deceased is my youngest son. Dhaneswar, by the time of his death, was reading in Panasapada College, but he was staying in Gopabandhu Mess, Puri town. Prashant, the accused, was working in a private company in Puri town at the time of occurrence. On 26/5/2006, on Savitri's Amavasya day, my son Dhaneswara arrived at our village around 9 a.m. After spending some time in our house, Dhaneswar, accused Prashanta, also arrived in the house of my mother at 10 a.m. On 26/5/2006,
Just a minute. You are leaving some portion of that evidence.
Proceeded to the house of my mother in our.
oh yes, my one line is there.
Yes, read it once again.
Yes, ma'am. After spending some time in our house, Dhaneswar proceeded to the house of my mother in our village. Apple line is actually. Then well, that next line will actually more legible confidence. Apple line.
Yes.
पढ़ो.
Accused Prashanta, page 73, ma'am.
Yes.
Accused Prashanta also arrived in the house of my mother at 10 a.m. On 26/5/2006, Dhaneswar stayed for 2 hours in the house of my mother and thereafter returned back to our house. In the evening, Dhaneswar again proceeded to the house of my mother. Half an hour thereafter, Dhaneswar returned to our house and while ironing one of his pants, complained reeling of head and called me. When I inquired from Dhaneswar the cause of his having reeling of head, Dhaneswara disclosed that after drinking milk in the house of my mother, from which the smell of petrol and kerosene was coming, and it was also tasting bitter. When Dhaneswar vomited, my husband arrived there. Dhaneswar lost his sense. I rushed to the house of my mother to know as to what milk my mother had given to Dhaneswar to drink. I met accused Prashanta and my mother in our house. I found accused Prashanta very much perturbed when he was in our house. My mother disclosed that Dhaneswar was complaining taste of bitterness while drinking milk, and hardly he had taken 2 sips and refused to drink the rest of the milk. I and my mother then returned back to our house. My son was removed to Chandanpur Panchayat Hospital, where the doctors, seeing the condition of Dhaneswar to be serious, referred him to DHH, District Headquarters Hospital, Puri. Dhaneshwar, my son, while being removed to the hospital, passed away. Accused Prasant left our village without telling anybody on the night 26/5/2006. I returned to the village again on the evening of 30th May 2006. After accused Prasanta arrived in his house, his father came to our house and called us to his house. I, along with my dear Manindhar Maharana, proceeded to the house of the accused. My mother also was there in the house of accused Prasanta. Besides us, Bhaskara Muduli of our village was also there in the house of the accused. Before us, the accused confessed that he had mixed Hilden pesticide in the milk to kill Dhaneswara and my mother. Accused Prasanta had purchased the poison to kill Dhaneswara and his Jejima from Chandanpur Bazaar 20 days prior to the occurrence. My husband thereafter lost the affair before the OIC Chandanpur PS. Maga Maharana of our village was contesting for the post of Sarpanch and was candidate against me. This is my lord in examination chief mail. And the persons whose name have been mentioned here, save and except mother, nobody else were examined. That Maninder Maharana, Bhaskara Muduli, and this third person also.
Manidhara Maharana.
Manidhara Maharana has not been examined. Bhaskar Muduli, who were witness to that confession.
Bhaskar Muduli.
Yes.
Manidhar out again.
And grandmother, the grandmother of the deceased. Grandmother of the deceased has been examined. He sees PW2 male. Then we'll cross examine some difference. May I?
No, this first part in page 73.
Yes, ma'am.
When the inquiry was made by this witness from the deceased regarding the cause of his reeling head. So the deceased disclosed that after drinking milk in the house of my mother, from which smell of petrol or kerosene was coming, it was tasting bitter when vomited. So here, at least before the mother, she has not stated who gave him the milk. That is one thing which has been there in that extrajudicial confession that is there.
They have stated, my lord. Everything has been canvassed here, my lord. Your lordship.
Okay, in the house of the mother,
yes.
Who else were staying? That evidence has come that apart from CHITTARANJAN and Dhaneshwar, this is my appellant. My mother had adopted. Adopted. My mother had adopted Pabani Maharana. Asha. ये होची तामाने पब्बनीर पुओ.
Pabbanir puo.
Appellant is the son of.
Okay. So Pabbani was alive.
Pabbani was alive because at that point of time he was alive because he had stated as his interest the PW1, the father of the deceased.
Just want to know that yes. How many family members were there in the house of the grandmother, right?
They were normally what I found from the record.
No, from the evidence it has to be collected.
Evidence it comes out, Pabbani and his wife and the accused. Those three along with the grandmother. Those were staying there.
Okay.
And the daughter was staying another place along with his family, with her family.
So that means this accused and his father, mother, yes. And grandmother.
Yes.
Okay. All right. Now you read the cross-examination.
Yes, madam. We live in a separate house in our village than the house of my mother. I am the only child of my parents. My mother adopted the father of the accused as he had no son. So such adoption had taken place when I was a child. It is not a fact that Pabani Maharana is hard of hearing. My mother is living with Pabani Maharana till today also. The accused is the only son of his father. My mother had a liking for my son Dhaneshwar. My lord, I'm just clarifying a little bit here. This is regarding hard of hearing the Pabani, because the PW1 had stated that he was not able to hear the things. That is what it has been clarified here, what I have understood from the deposition. My lord, may I proceed?
Who is Pavani?
Pabani is the accused father. Father of the accused.
Acha, accused father. Father of the accused, okay. Yes.
In the evening of 26/5/2006, I had not gone to the house of my mother, that is before Dhaneswar drank milk. I was not present when Dhaneswar drank milk. We had good relationship with the accused prior to the occurrence. On 26/5/2006, the accused had not come to our house. Information regarding the occurrence was lost by my husband before the OIC Chandanpur PS only on 31/5/2006. On 26/5/2006, after my son died, no information was lodged before the OIC Chandanpur PS. I am acquainted with the handwriting and signature of my husband, Pranakrishna Maharana. This is the signature of my husband, Pranakrishna Maharana, which has been marked as exhibit 1 by 1. Maguni Maharana happens to be the brother of my sister-in-law. Yeah, Pramod Maharana, Giridhari Maharana, Bauri Bandhu Maharana, who have signed on exhibit 1 the inquest report, they all belong to our village. In these names, my lord, Pramod Maharana, Giridhari Maharana, or Bauri Bandhu Maharana. Bauri Bandhu Maharana has been examined as PWE. Pramod Maharana, Giridhari Maharana have not been examined.
Giridhari Maharana has been examined.
Giridhari Maharana.
Yes. PW6. PW6.
Madam. PW6. I'm sorry. Giridhari Maharana has been examined.
Yes.
Giridhari Maharana has been examined. I'm sorry. Bauri Bandhu has been examined, but Pramod Maharana has not been examined. Police had examined me in this case. It is not a fact that I did not state before police that on 30th May 2006 evening, the father of the accused came to our house and called me to his house, and therefore I, along with my dear, proceeded to the house of the accused. It is not a fact that I also did not state before police that when on the evening of 30th May 2006 we arrived at the house of my mother, found my mother and Bhaskar Muduli were present in the house along with the accused. It is not a fact that I also did not state before police that in our presence the accused confessed to have
proved. All these things have been proved through the IO.
No, my IO has stated, well, kindly appreciate chemical examiners report which has been given by the IO.
I'm asking questions, please. When you have confronted with reference to your previous statement,
yes,
then it is the duty of the defense counsel to prove, because he has stated it's not a fact.
Yes.
So it has to be proved through the investigating officer. Who is the SI? The
PW12, man.
So whether it has been proved through these contradictions have been proved or not?
But that has been examined, my lord, subject to my lord appreciation, because a lot of things have been explained there.
The
things which has been stated before the IO, whether it has been confronted to him or not. That is what.
No, the thing which has been confronted to the witness has been put to the IO or not. It's just the other way.
This part, my lord, no, deposition doesn't.
PW10.
PW12, my lord.
Come to paragraph number 12, page 89.
Yes.
What sort of preparation is this?
I had examined Mini Maharana, PW10. PW10 did not state before me on 30th May 2006 evening. The father of the accused came to their house and called her to his house, and thereafter she, along with the driver, the river, proceeded to the house of the accused. PW10 also did not state before me that when on the evening of 30th May 2006 they arrived at house of her mother, found her mother and Bhaskar Muduli present there along with the accused. PW10 also did not state before me that in their presence the accused confessed to have mixed poison to milk to kill her son Dhaneswar and his Dejma. PW10 also did not state before me that the accused Prashanta confessed before us that he had purchased Hilda poison to
Mani Maharana's statement that you heard 161. Hmm. Argoli, Odia statements. Uddori Maharana. Money. That is page 103. This is money, not money. Money. Wife of so and so upon Bayan Manasur Marana Moro Sana Thila. Okay. The Ponasura College +2 science second year chapter into se Puri. I go on the Mesrai Padapo. I wrote Prashant Marana. The Kalbalan tried. All of Pata Podamuchar Puri private company piano Chakiri Gurgla. Prashant more Podamuchar book of Pata Pulsar is suffering. Manasur says a valor and the Kotha. CORAM पूर्व प्रशांत जानता है मैंने साबित्री अमावस्या दिन स्वान से छुट्टी घर पास सबुतर बड़ी घर को जाए केयर हेड कर प्रशांत पूर्व अनुमान रवि धनेश्वर रास्ता बटाई योजना प्रसारण धनेश्वर बैंक पैसा क्या क्या तो भाव जड़ित रामदेव मसानो सम्मान 24/5 6 तारीख 9टा बेले आसी घर पहुंचला घर समारोह सबुतर बड़ी मामू को पढ़ाई प्रशांत महाराणा जितेबाला जानिला मनुष्य गाँव पर से तार पूर्व योजना पूरे दिन बारी चिरो मिसाइल कारण मिशन श्रद्धा क्षीर प्रिय यही सब कांड कर प्रशांत अवसर बाट को हत्या कर बसते आम घर विभिन्न काम व्यस्त रहा दिन समय क्रिकेट खेलला निज सार्ट को इस्त्री करने सजाई रखला यापर संध्या 6टा बेलू उक्त दिन सुआंश संध्या 6टा बेलू पुणी धनेश्वर तार मामू घर बुलिया सेठारे तार आई सुआंश किसी जानी न था श्रद्धारे तो विष मिश्रा क्षीर एक ग्लास धनेश्वर को पीवा देला यही सुजोग को प्रशांत अपेक्षा कर उपस्थित होता जेजेमा धनेश्वर को देला मेरा योजना कार्य पहला यही आई घरे क्षीर पीछे कहला से प्रशांत बसला धनेश्वर मानसी संगे संगे प्रशांत प्रशांत इंजेक्शन भी पूरी बड़ा रखता प्रशांत कीटनाशक सावित्री अमावस्या दिन पक्ष मुझे जानी पारि प्रशांत स्थित इतस्तत जना सका पूरी पढ़ाई गला से निज पाप को विचार संधान गाँव को सामान्य So it was purely pesticide, besides the indigenous and Shade of Tapuja can do some also is such a besides not allow a portion pilot for the long so the completion of chicken series part in the from the ग्राहक का ऐसे लोग सामान्य पंचायत करें response besides the common judgment survey judging also because I think it's going to be pesticide so it the I think question what should be anybody has been examined that about the appellant procuring that
PW3 miler.
poison.
PW3 then hostile became hostile actually.
Oh, he has not supported.
Then miler
Wait.
fertilizer and pesticides soft.
yes.
Damodar group.
Accuser never found myself. And in a poisoning case, the availability of the poison with the accused is also one of the important factors. So, and what about whether that milk glass that was seized and what?
That fixed nothing, my lord. That is
Oh.
last examination report, my lord, is page 94, my lord. A regarding that container which carrying that poison, A2 and A3 are the Dekchia and the glass mine.
So insect what detected, bro?
First A, that the
A
container where the poison was there, pesticide was there.
A1 red color 3 डिब्बा अच्छा था এটা কোড যাওয়া বতলা
সেটা leading to discover ଦେଖିଛନ୍ତି
আচ্ছা so A রে হচ্ছে না leading to discovery କୋଉ ଜାଗାରେ
near pond my lord ଯୋଉ ଜାଗାରେ ସେ ମାରି ଦେଇଛି ମାଛ ମରିଗଲେ ବୋଲି ଲେଖା ହେଇଛି ଗୋଟେ ଜାଗାରେ ସେଇ ପାଖରେ ଦେଖିଲି open space actually that part also
ବାକି ଯୋଉ ଚାହା ଯୋଉ ହଉଥିଲା ସେଟା ହଉଛି ଆଲୁମିନିୟମ ଡେକି ଏ ଯୋଉ କ୍ଷୀର ଯୋଉଥିରେ ହଉଥିଲା ସେଟା ଆଲୁମିନିୟମ ଡେକିଛି ଆଉ ଯୋଉ ଗ୍ଲାସ ଟା ହଉଥିଲା ସେଟା ହଉଛି A3 ମାନେ A2 ଆଉ A3 ଟା ହଉଛି relevant
yes ma'am
so and so could not be detected and PM report
my lord doctor statement P that is PW5 my lord that speaks poison lactopathy it was added but poison part was not clear then
yes sir let us come to
PW5
Viscera has not been tested.
Viscera was sent it was mentioned but there is no viscera report my lord no report my lord because I also could not establish before the line code below
oh he didn't give the final opinion
yes
he kept the opinion reserve awaiting the viscera
yes that
and it did not reach the court even
no my lord because I could not get from my record my lord because I stated clearly it could not the documents which are in produced it is not there the chemical examiner report is not there Paragraph 2, my lord, regarding pesticides, he has mentioned.
Because in a case of this nature, the viscera report has got importance. How the prosecution did not prove it. It was sent, it was the duty to collect it and
Because this is a very vital piece of.
Even that is not exhibited, my.
He is saying about pesticides.
Yes.
Whether organophosphorus or not.
Yes.
we say that definite opinion could not be given. Therefore, I preserve the internal organs of the disease like spleen, liver, stomach, and its contents, or so on. So, kept handed over so on. Viscera report not proved. Glass and chemical and whatever motive part is there in this 161 statement, that is not there in that because it appears that they were irregularly visiting terms and any witness has stated about the motive part. 161 motive ଅଛି କଣ କି ଇଏ ଭଲ ପଢୁଥିଲା ଆଉ jealous ସେଥିପାଇଁ ତାକୁ ସେଇ ବିଷୟରେ ତ ଆଟଲିଷ୍ଟ PW10 ର ଏଭିଡେନ୍ସ ରେ କିଛି ଆସୁନି ଆଉ କୌଣସି ସାକ୍ଷୀ କହିଛନ୍ତି
Actually, the vital witness of PW1, 2, and 10. Okay. 1 is the father, 2 is the grandmother, and 10, my lord, the mother. And one more thing, my lord, subject to my lord's acceptance, that Exhibit 13, the document which I have with me, that is chemical evidence report regarding the utensils. But Exhibit 13, chemical evidence report, my lord. In my record, my lord, what paperwork I have with me, that Exhibit 13, if I will assume that that document which I have been showed for lordship, page 94, regarding chemical exam report of utensils. But chemical exam report of that private parts, of the body parts.
That is the viscera report.
Yes.
That is not there.
Yes, that is.
That is. It should have been mentioned at least in the exhibit.
Yes,
list.
that is not mentioned.
That is not mentioned.
But Lanet Court will have taken note that chemical exam report is there. That
no, chemical examination report is this one.
This one only.
This one means where only in that container that is there, or otherwise the glass and the aluminum dekichi.
Yes.
Maybe that was used for preparation of that milk.
Yes, ma'am.
Okay, so that contains nothing. So poison could not be detected.
In the statement of the I.O. Miller, in the page 81, para 3, he has mentioned that this is the chemical examination report marked as Exhibit 13. On receipt of the chemical examination report, I made a query to the director SFL Bhubaneswar if the poison dictated in the viscera matched the poison.
Viscera report तो नहीं.
सीधे सीधे जो देजी कोरीटा भी से लेटर भी जाइए कि exhibit 14 बता रहा
आकु देखी कि नहीं डॉक्टर कौन कोई वो ये एग्जामिनेशन रिपोर्ट देखी नहीं डॉक्टर की डॉक्टर viscera पाई से वेट करतिला
नहीं से लेटर करछि टू द एसएफएल हां किंतु तापर से लेटर कोरी माने एटा भी आसीनी से
हां सेही viscera रिपोर्ट टा ऑर्डिनरली ए टाइप रो केस रे प्रोड्यूस हुए एवं तांको ओपिनियन मगा जाए कारण जदि viscera रे मन करंतु आपनकर आसीला नाही पॉइजन दैट एक्सक्लूड्स दैट तेणु एक्सक्लूड हेले सी पुनी ओपिनियन दबो ये कोन पई
व्हाट इज द
तेणु कारण बॉडी रे इंजुरी नाही आपनकर पॉइजन केस नुहे तो आसी जीवो होय तो नेचुरल डेथ हे पारे So who are the other important witness according to
PW2 and PW1 also.
One.
PW2 is the grandmother who administered the poison.
Administered the poison, administered.
That milk was given to his grandson. This is.
Because the drying declaration, which is one of the most important aspect. See, he has not stated that it was administered by this appellant. Rather, it is the case of the prosecution that the milk was given by the lady, that is PW2, মানে grandmother जोटाको ବର୍ତ୍ତମାନ ହଉଛି ଯେ କ୍ଷୀରରେ ମିଶେଇଲା କିଏ
ଏବଂ ସେଟା
ମିଶିଥିଲା କି ନାହିଁ ପ୍ରଥମ କଥା, ଆଉ ଯଦି ମିଶିଥିଲା ମିଶେଇଲା କିଏ। ଫାଷ୍ଟ ହଉଛି ଆପଣଙ୍କର କ୍ଷୀର ଗ୍ଲାସ, କ୍ଷୀର କଣ୍ଟେନର ଯୋଉଥିରେ ଇଏ ହଉଥିଲା ଫୁଟା ହଉଥିଲା ତାକୁ ଆପଣ ପଠେଇଲେ ତା ଦେହରେ ନାହିଁ। ଭିସେରା ରିପୋର୍ଟ ଆପଣ ପ୍ରଡ୍ୟୁସ କଲେଣି, then how
it will
the
be poisoned?
prosecution would succeed in establishing that and the doctor is giving no opinion,
No
that
opinion,
I am
reserve.
giving the opinion
Yes.
reserve. So how it would be a case where the prosecution has proved that he was administered poison for which the death occurred? That is one of the you are to answer it. All right, you come to that 1 and 2. You say they are the vital witnesses.
Yes,
Let us come to that.
First, my PW1, yes, that is at page 44, running page 44.
Pranapushpa Maharana.
Yes, ma'am.
He is the father of
The
Father.
May I read?
Yes, yes.
I know the accused in the dock, and he is my nephew, being the son of my brother-in-law, Pabani Maharana, brother-in-law Pabani Maharana. The deceased Dhaneshwar is my youngest son. The accused and we belong to one village. Dhaneshwar, my deceased son, was prosecuting his studies in Panasapada College in +2 first year science. He was very good at his studies. On 26/5/2006, that is on the Sabitri Amavasya day, Dhaneshwar had come to our house from his mess, that is Gopamudu mess in Puri town. After reaching our village, my son Dhaneshwar had gone to the house of Sodari Dei, his maternal grandmother, and in the evening, Dhaneshwar returned to our house. My mother-in-law gave milk to Dhaneshwar to drink, and after having a sip, complained of bitter taste and reported the matter to his grandmother. Thereafter, Dhaneshwar returned back to our house, and while ironing his shirt, reported to his mother and suddenly fell down crying aloud. We removed Dhaneshwar in an auto rickshaw to Chandanpur hospital, where the doctor gave an injection and referred Dhaneshwar to district headquarters hospital, Puri. And while we are removing Dhaneshwar to Puri, he died on the way. The doctor of the district headquarters hospital, Puri, after examining Dhaneshwar, declared him brought dead and reported the matter to Kumbharapada police station and Chandanpur police station. The postmortem over the dead body of Dhaneshwar was conducted, and I identified the dead body of my son Dhaneshwar. Police held inquest over the dead body of my son. The inquest report was prepared in my presence by police, and I had signed on that. This is that inquest report prepared by police marked Exhibit 1, and this is my signature Exhibit 1 marked as Exhibit 1 by 1. 5 days after the occurrence, that is on 30th May 2006 around 9 p.m., in presence of villagers, the accused admitted that he had administered poison to the milk for which Dhaneshwar had died, and Sodari also would have died by consuming the said poisonous milk. The accused, when made such extrajudicial confession, my younger brother Maninder Maharana, Bauri Bandhu, and my wife Mani Maharana were present. So also my mother-in-law Sodari Maharana was present. Pabani Maharana was also present when the accused made such extrajudicial confession. I reported the matter in writing before the police. My son-in-law, Dayanidhi Das, scribed the FIR according to my dictation. This is that FIR lodged by me, marked Exhibit 2, and this is my signature, marked Exhibit 2 by 1. The contents of the FIR were read over and explained to me, and after knowing the contents of the FIR to be written as per my dictation, I put my signature on the FIR. Cross-examination by defense. When the accused on 30th May 2006 made the extrajudicial confession before the villagers and my brother, wife, and mother-in-law, I was not present. I was examined by police in this case. This case, it is not a fact that My brother,
Just a minute. What this line says? When the accused
when the
35 so and so
yes,
made extrajudicial confession before the villagers, my mother and my mother-in-law, I was not present. So
My
it comma out
My brother's wife.
yes, sir.
uh,
I was not present, man.
that means he was
He
not.
was not present.
Okay. Yes.
I was examined by police in this case. It is not a fact that my brother Maninder was not present when the accused made extrajudicial confession before the villagers that he had administered poison to the milk which Dhaneshwar consumed and died. It is not a fact that I had stated before police that my younger brother Maninder was informed regarding the extrajudicial confession alleged to have been made by accused before the villager by his father Pavani Maharana. My son did not vomit when he fell down while ironing, but when I came to the auto rickshaw to remove Dhaneshwar to hospital, I found froth coming from the mouth of the Dhaneshwar. Pabani, my Sala brother-in-law, has been adopted by my mother-in-law, Sodari. I was there in my house when my son Dhaneshwar fell down. I had gone through the inquest report before signing on the same, and the columns of the inquest report have been filled in Oriya. In the inquest report, Exhibit 1, in column number 9, it has been mentioned that there is there is no doubt that Dhaneshwar had died because of epileptic fits, and Maguni Maharana had opined about such death, in whose presence also the inquest was conducted by police. It is relevant, kindly appreciate, madam. Maguni Maharana happens to be the brother-in-law of my own brother Maninder. All the witnesses have signed on the inquest report are my agnetic brothers. After knowing the inquest report and the contents to be true, we all had signed on the same. The accused was not mindful about his studies. It is not a fact that the accused never believes anybody, nor anybody trusted him. The accused, 5 days after the death of Dhaneshwar, in his own house, confessed his guilt when I learned from Pavani, my Sada. After
Just 1 minute. I say exhibit 31, exhibit 1. List of exhibits.
It's the user.
40. 40 now. 40 टा कौन accused statement? दियो तलो अच्छी तंबर दियो.
41, 41, 42. 40, 41.
ओ अच्छा 40 देखिए. अरे এইটা কোন তো মানে exhibit 1 টা বাহার করে দিও.
সেইটা 41 দেখো 42 43 exactly 43 inquest report.
ଏଇଟା ୟୁଡି କେସ ରେ ସେତେବେଳେ କାରଣ ଏଫଆଇଆର ହେଇ ନଥିଲା.
yes, ma'am.
ଏଫଆଇଆର ହେଇଛି 31 ତାରିଖ ଦିନ.
Yes, ma'am.
ୟୁଡି କେସ ରେ ସୋ obviously ସେତେବେଳକୁ କନଫେସନ ହିଁ ନଥିଲା. କନଫେସନ ଆପଣଙ୍କର ଆସିଲା 30 ତାରିଖ ଦିନ. ତେଣୁ ସେତେବେଳେ ସେମାନେ ଓପିନିଅନ ଦେଇଥିଲେ ଏଇ ଯୋଉ ସର୍କମଷ୍ଟାନ୍ସେସ୍ ରେ କଜ ଅଫ ଡେଥ ମୁଁ କଣ ମୁସ୍ତଫା ଧନେଶ୍ୱର ମହାରଣା ଅପସ୍ମାର ବାତରେ ମୃତ୍ୟୁବରଣ କରିଅଛି, ଏଥିରେ ସନ୍ଦେହ ନାହିଁ. ମାଗୁଣି ମହାରଣା କିଏ?
Magul Maharana, one of the real brother-in-law of the Prashant Mailot.
Okay.
Another brother-in-law is this. Sano Bhaira Sola.
ଏ ବାକି ଯୋଉ PW1 is a signatory to the
PW1 signatory.
ନାଟା ହଉଛି
Prashant. Sorry.
ପ୍ରାଣକୃଷ୍ଣ.
Pranakushna.
is a signature.
Yes, yes,
To the left side.
PW1, right.
But say Maguni or Maninder has not been examined.
That means
Magunia Monidhara.
Monidhara. Sorry. Monidhara.
that means inquest report preparation पर्यंत काहारो संदेह नथिला appellant उपरे.
Yes, that one.
Number two, it came to light according to the prosecution that on the due to that extrajudicial confession.
Yes.
Okay. माने ये भी in presence of so and so accused actually let me give the verbatim unusual poison should be made for them. Yeah. Yes, come to the next paragraph.
Yes, ma'am.
That paragraph 6.
The accused was not mindful about his studies. It is not a fact that the accused never believes anybody nor anybody Trust him. The accused 5 days after the death of Dhaneshwar in his own house confessed his guilt, which I learned from Pavani Maisala. After hearing about the extrajudicial confession alleged to have been made by the accused from his father, Pavani, I proceeded to Chandanpur PS to lodge the report in writing. The accused was working as a peon in a private concern at the time of occurrence. In Chandanpur hospital, doctor gave an injection to Dhanesar, and as per the prescription of the doctor, I had purchased the same from medicine shop of Chandanpur Bazaar, but I have not preserved the prescription nor the cash memo. I also did not produce such prescription and cash memo evidencing purchase of injection before police. Police started the UD case regarding the death of Dhaneswar basing on the casualty memo of the district headquarters hospital Puri. It is not a fact that the accused had not made any extrajudicial confession before anybody to have administered poison to the milk which my mother-in-law had given to Dhaneswar to consume. My mother-in-law who lives in our village is in visiting terms with our house. It is a fact that my mother-in-law, Sodari, has good relationship with my Sada Pabani and his children. Then further cross-examination. It is not a fact that I did not state before police that the accused when made the extrajudicial confession. My younger brother, Maninder Maharana, Bauri Bandhu, my wife, Mani Maharana, and my mother-in-law, Sodari Maharana, and Pabani Maharana were present. My wife of Mani Maharana was Sarpanch at Pratap Purushottampur GP under Puri Sadar block.
No, this paragraph 6, page 47.
Yes, madam.
The second sentence.
Yes.
That the accused 5 days after the death of Dhaneswar
Yes, madam.
in his own house confessed his guilt,
Yes.
which I learned from Pabani Maisala.
Yes.
That means PW1 had no direct knowledge.
No.
He came to know from Pabani.
Yes,
Pabani has not been examined. So if the extrajudicial confession was not made in presence of PW1,
Yes.
then who else has stated about that? One is that PW10, of course.
PW10 and PW2, my lord.
2, acha. Let us come to then PW.
That is the grandmother of the deceased.
Come to PW.
Yes, ma'am. Page 49, madam. The accused in the dock is my grandson. That is, he is the son of my adopted son, Pabani. Pabani, Pranapushna, the informant of this case, is my son-in-law. Dhaneshwar, the deceased, is the son of Pranakrishna. Pranakrishna and myself are living in one village. Dhaneshwar was reading well, and therefore I had tremendous liking for Dhaneshwar. Dhaneshwar, whenever comes to my house, I used to take care of him, and for that the accused was jealous and therefore also used to misbehave with me. The accused was not good at his studies and had read up to class 7 or 8. The accused was serving in Puri in a private farm as peon. On last Savitri Amavasya day, Dhaneshwar had come to my house around 9 a.m. Dhaneshwar inquired about my well-being and then proceeded to his house. Around 10 a.m. that day, the accused also arrived at my house from Puri. The accused knew about the coming of Dhaneshwar on Savitri Amavasya day to my house. The accused stayed in my house that day. The parents of the accused had gone to the temple when Pasanta arrived at my house. I had kept milk after boiling the same by hanging in a sikar in my bari ghar and had covered the pot. That day evening, when Dhaneshwar again came to my house, I inquired from him whether he has taken anything. When Dhaneshwar told that he has not taken anything, I gave him milk by bringing the same from the pot which I had kept in my barighar from the sikar. Dhaneshwar, the deceased, after taking a sip of the milk, complained, "Ai, କ'ଣ ତୁ କ୍ଷୀରରେ ପକେଇ ସିଝେଇଛୁ ଯେ ପେଟ୍ରୋଲ ଏବଂ କିରୋସିନର ଗନ୍ଧ ବାହାରୁଛି, ପିତା ଲାଗୁଛି ଏବଂ ପିତା ଲାଗୁଛି." What has been mixed up with the milk, for which the taste of milk has become bitter, and whether it is mixed with kerosene or petrol. After washing his mouth, Dhaneshwar returned back to his house. When Dhaneshwar drank the milk, the accused was present in my house. When Dhaneshwar left my house, the accused followed him. I when also tested the milk, found the same emitting bitter smell, and also tasted bitter. I used to bring milk from the house of Aparti. I also gave a little milk to my daughter-in-law, Radhamani, who also complained that the milk tasted bitter. Aparti informed me that he had supplied milk to 2 to 3 houses and gave some milk to us to drink, and when we drank those milk, the same did not taste bitter. While returning from the house of Aparti, I poured rest of the milk which I had kept in the dekchi in the water of Linga Pokuri, and the fishes of the said pond, after consuming the said milk, died.
No, but nothing has happened to this lady.
Nothing has happened to this lady.
Just read again.
Yes, ma'am.
After washing the mouth, Dhaneshwar returned back.
Yes.
When Dhaneshwar drank the milk, the accused was present. Okay.
Yes.
When Dhaneshwar left the house, accused followed him. I
When
also tasted the milk. This is most important.
Yes, ma'am.
Found the same. It's all right. It is bitter, but no, nothing happened to this lady.
Then I also gave it to little milk to my daughter-in-law.
Daughter-in-law, Radha Mani. That means it is the mother of the appellate.
Yes.
Okay. Also complained bitter. Okay.
Yes.
Then Aparti informed him that he had supplied Aparti ki.
Aparti the milkman.
Informed that he had supplied this milk to 2 to 3 houses and gave some milk to us to drink. When we drank the milk, the same did not taste bitter. While returning from the house of Aparti, I poured the rest of the milk which has found open. Okay, continue.
Sir, I am seeing that paragraph next one, 51. I am seeing that rushed to the house of the Dhaneshwar and found Dhaneshwar lying unconscious, and Prasanta was silent. Spectator to that, Dhaneshwar was removed in an auto rickshaw to Chandanpur Hospital, and from Chandanpur Hospital, Dhaneshwar was referred to District Headquarter Hospital, Puri, and on his way to District Headquarter Hospital, Puri, Dhaneshwar died. On hearing the death news of Dhaneshwar, Prasanta, the accused, became restless and was mentally perturbed. On the next day of the death of Dhaneshwar, Prasanta returned back to Puri to join his duties. Prasanta returned back to the house 5 days thereafter, and in the night around 9 p.m. Prasanta, the accused, in presence of me, my daughter Mani Maharana, Radha Maharana, Pabani Maharana, Bauria Maharana, Manidhara Maharana, and Manidhara Maharana confessed to have mixed poison to the milk which I had kept in Dekchi to kill Dhaneswar and me, as Dhaneswar was reading well and as I had tremendous likeness for Dhaneswar. Pranakushna Maharana, my son-in-law, on the next day reported the matter at the police station. I had washed the dekchi in which I had kept the milk, and so also the glass. Dhaneswar was quite hale and hearty prior to his death. This is that small aluminium dekchi in which I had kept the milk after boiling is marked as MO1, and this is that steel glass tumbler in which Dhaneswar drank the milk marked MO2. Cross evidence by defense. I and my husband had adopted Pabani Maharana, the father of the accused in the dock. Pabani is a deaf. Pabani had a daughter who is since dead, and therefore the present accused is his only living issue. Now the mother of Dhaneswar was given in marriage in our village, and such marriage took place after adoption of Pabani. 1 minute, may I? This Pabani was deaf. The mother is saying this. That is why that one was confronted there, man. The Pabani, the father of the accused, was deaf, and he communicated to the father of the deceased. This is why I'm repeatedly pointing out that he was deaf. How he could communicate? He could gather information from the accused. Thereafter, he communicated to the informant.
But in any case, two of them have not been identified.
No, that is not. This is problem. The deaf part is there. That is why.
Yes. Next.
Yes, ma'am. The mother of Dhaneswar was given marriage in our village, and such marriage, that is sixth line, or page 52. And such marriage took place after the adoption of Pabani. We are all weavers. Pabani cultivates our landed properties besides weaving saris. In between the two grandsons, I had a tremendous likeness for Dhaneswar. I had not given any landed properties to the mother of Dhaneswar. My daughter was the sarpanch of our village, and she has also won this time in the election for the post of the sarpanch. The accused was not good at his studies, and whiling away his time in the village without attending any work. The accused talked to his parents, but he had no good relationship with me. My husband died 12 years back. After the death of my husband, nobody took care of me, and I used to spin and ache out my living. On the advice of the doctor, I used to bring 250 milliliters of milk from Aparti of our village for my own consumption. After boiling the said milk, I used to keep the same in my barighar by covering the pot. I have a separate hearth in my barighar. I had given a little than half a glass of milk to Dhaneswar to drink, and Dhaneswar drank half of the milk given to him. After taking a sip, complained of bitter taste and did not drink any more. And after keeping the glass with the rest of the milk, complained smell of petrol and kerosene in the milk and left my house. When Dhaneswar complained after drinking little milk from the glass of smell of kerosene and petrol, and after having a sip left the glass with the rest of the milk, I thought that something might have fallen in the milk, and I thought that kerosene might have fallen to the milk, or some insects might have fallen also. Linga Pokhari, where I poured the rest of the milk from MO1, is a public pond, and the death of Dhaneswar, when Prasanta, the accused, came to our house, he voluntarily confessed before us, and nobody had asked him anything about the death of Prasanta. For the first time, I am deposing about the case before this court. Soon after Prasanta, the accused, confessed his guilt before us, I disclosed the same not only to my neighbors but also before the entire villagers. And on the next day, Thereafter, police also examined me. It is not a fact that I have not stated before police the names of persons before whom the accused had made the confessional statement. It is not a fact that I did not state before the police that the accused had confessed before me and others to have mixed poison to the milk which I had kept in Dekchi to kill Dhaneshwar as Dhaneshwar was reading well and as I had tremendous liking for Dhaneshwar. It is not a fact that I had stated before police that the accused confessed before us and the villagers that he had mixed insecticides to kill me and Dhaneshwar since Dhaneshwar drank that milk died. It is not a fact that I did not state before police that I had washed away MO1 and MO2, namely the Dekchi and the glass. It is not a fact that I did not state before police that on the date of occurrence, that is on Sabitya Amavasya day, the parents of Prasant had gone to the temple and Prasant alone was present in the house.
Who has also not stated before police.
No.
This extrajudicial confession part confronted and proved through the confrontation part. Okay. What are the other evidence?
Other evidence, my lord, 3 hostel, 4 hostel.
Hostile.
4 is also stated at the inquest report signatory, my lord, and the statement which had been
He has been declared hostile.
Yes,
Five,
and my lord, 5 is the doctor, my lord, who made the postmortem. 6, my lord, he was seizure witness, my lord. He is a co-villager. So inquest report. Signatory. And my lord, 7 is also my lord, one doctor who referred the matter to Thana for a registry affair.
Legally medical.
Legal, yes.
Okay.
And 8, my lord, is also hosted seizure witness, my lord.
Not know anything about the case. Okay.
And 9, my lord, another brother of the PW4 who was hosted, he is also hosted.
Hostile, right.
And 10, my lord, mother. 11 is the my lord, initial investigating officer who made the inquiry, my lord. May I read, my lord? It is little bit relevant.
Yes.
That is page 77, my lord. On 27/5/2006, I was ASI of police attached to Chandanpur PS. On receipt of the casualty memo from Dr. Kumudini Mishra, Medical Officer, District Headquarters Hospital, Puri, OICC DP Das of Chandanpur PS, registered UD case number 11 of 2006, and directed me to inquire into the matter. At 7:30 a.m., I, along with Constable 232 S. Malik, proceeded to the district headquarters hospital and reached there at 8 a.m. I examined Dr. Kumudini Mishra and thereafter in between 8:30 a.m. to 9 a.m. held inquest over the dead body of the deceased Dhaneshwar Maharana, son of Pranakusha Maharana of village Brahmana Arandia. In the district headquarters hospital premises where the dead body of the deceased was lying. Exhibit 1 is the inquest report prepared by me. I examined Maguni Maharana and Pramod Kumar Maharana, Giridhari Maharana, Bauri Bundi Maharana, and Pranakusna Maharana. I prepared the dead body challenge and sent the dead body for postmortem examination. This is the dead body challenge prepared by me, marked as Exhibit 8. On 27/5/2006 at 9:40 a.m., I left the district headquarters hospital Puri for village Brahmana Alandia and reached there at 10:05 a.m. I made confidential inquiry as to the cause of death of the deceased Dhaneshwar Maharana and directed Gramarokhi Akshay Malik to take up further inquiry and sent for the inmates and neighbors of the deceased. I received the PM report of the deceased 1/6/2006. I sent the viscera of the deceased for chemical examination to the director of the SFSL, Bhubaneswar. I submitted final report UD case number so and so 11 of 2006 on 1/6/2006. This is that final form submitted in Chandanpur UD case number 11 of 2006 marked as Exhibit 9. Cross examination by defense. During the inquiry in Chandanpur UD case number 11 of 2006, that is from 27/5/2006, till the date of submission of final form 1/6/2006, I did not get any information or may tell about the involvement of the accused Prashant Kumar Maharana is causing the death of deceased Dhaneshwar Maharana. It is important, my lord. The father of the deceased and other witnesses had disclosed before me that Dhaneshwar Maharana had died because of epileptic fits. Maguni Maharana is the maternal uncle of the deceased. This part, my lord, initial inquiry, it was found that epileptic fits he might have died. What transpires from the deposition of PW9, my lord. And
No, but that is the report of doctor.
That is not government actually. That is initially, my lord, there was no report. SFS, it was referred. So what is
what is the postmortem cause of death? Reserved. So how can even apparently the doctor is not giving any opinion
Yes, sir.
that he had epileptic.
Yes, sir. That is not.
So had it been so, probably doctor would have opined that. Nothing of that sort is there.
Yes.
Next, my lord, IO, my lord. PW12, my lord.
Okay, you please take your seat. Mr. Das,
My lord.
prosecution case is that appellant procured poison, mixed it in the milk, which was kept by the grandmother.
Yeah.
That was given, that one glass of milk was given to the deceased
By the grandmother.
by the grandmother PW2. He just took a sip of it and rest he left because it was bitter.
Yeah, he has taken half of it.
No.
No,
Sip of it.
half.
After taking
Half-
a sip,
half-
he
half-
complained.
No, please
My-
come to. Half anila, gote glass ro odha dela.
I am coming.
Please come to PW2.
PW2, my lord.
जी की कौची आमे मध्य ताको टेस्ट करू.
Right. Welcome to the PW2.
You come to paragraph number 6, page 52.
My lord.
Page 52, paragraph
There are
6,
my lord.
five,
I am
6
reading.
lines from the bottom.
My lord. I am just reading out from the third line, my lord.
Okay.
I have a separate heart in my arch in my barikar.
Right.
I had given a little
Than half a glass.
then half a glass of milk to Dhaneshwar.
ଆମେ ଅଧ ଗ୍ଲାସ ରୁ ଟିକେ ବେଶୀ ତାକୁ ଦେଇଥିଲା ପିଇବା ପାଇଁ.
Dhaneshwar drank half of the milk given to him. ତା ଯୋଉ ଅଧା ଦିଆଯାଇଥିଲା ଅଧାରୁ ଅଧା ପିଇଲା, not a sip.
ତାପରେ ପଢନ୍ତୁ.
ହେଲା କି? After taking a sip, complained a bitter taste and did not drink anymore. ଯୋଉ ଗୋଟେ ସିପ୍ ପରେ କହିଲା କିନ୍ତୁ ଏତେ ପୁଣି କହୁଛି half of the ଯଦି ଦିଆଯାଇଥିଲା ତାର half ପିଇଛି.
ଠିକ.
half ପରେ ସେ ଗୋଟେ ସିପ୍ ରେ ହତେ ଏକାଥରେ ପିଇଛି, half ପିଇ ଦେଇଥିବ. Then ସେ ଟେଷ୍ଟ କଲା ତାପରେ mother.
Okay, let us stop there. Now, the milk was administered or given by PW2.
Grandmother.
Okay. So, thereafter the evidence has come, the very same milk was taken
by the grandmother
PW2 herself and another girl,
The mother of the deceased,
Right.
mother of the accused.
mother of the accused. So, no reaction to them. Now, your doctor is not confirmed what is the cause of death. He is keeping the opinion reserved. Right. The utensils in which that milk was prepared and the glass in which that milk was given, those were sent for C examination. Of course, it was washed.
Yes, exactly.
Nothing was found in it. Doctor kept the viscera and the viscera was sent, but no viscera report has been produced, and it is in a case of this nature, viscera report should have been not only produced, it should have been also
vital
given to the doctor for his final
opinion.
So, if that is not there,
The cause of
then
death is not
how you say that the deceased died of poisoning? That is the most important factor. So, if then comes the source of procurement, The only evidence is PW3. He has not supported the prosecution case.
Right.
So the source of procurement evidence nahi. Deceased died of poisoning say evidence nahi. The only thing remains is the extrajudicial confession. Extrajudicial confession no tinita witness kohuchandi. 1, then 2, and then 10. Right? One is not a witness
To the direct.
He
heard
came
from
to
the.
know from that one Pavani.
He has not been examined.
He has not been examined. So far as 2 and 10 are concerned, if you compare their previous statement with the present statement,
161 and the
161, that has been proved to the investigating officer. So
They have
there
not
are
stated it.
material contradiction in that. And extrajudicial confession, as such, it's a weak piece of evidence.
but it should be
And it should be corroborated.
Corroborated.
Corroborated means at least medical
Huh.
evidence যদি ଆପଣଙ୍କର ଥାନ୍ତା,
ତାହେଲେ
it's a case of
Yes, sir.
poisoning,
Right.
ତାହେଲେ ତାକୁ corroborate କରିଥାନ୍ତା। ସେଇଟା ଯେହେତୁ ଆପଣ produce କଲେନି ଇଏ କଲେନି, ତେଣୁ ଖାଲି ଏଇ ଯୋଉ ଗୋଟେ, and you see if PW or the deceased on the first day itself on 26th, he disclosed that he has given the some milk and thereafter this reaction. And ମା ମଧ୍ୟ କହିଲା ଯେ ଆସିଲା ଦେଖିଲା ଏଇ ସବୁ ଜିନିଷ ଯଦି ହେଇଥାଏ, ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ତାର କିଛି ସ୍ୱର ଶବ୍ଦ ନାହିଁ। ତା ପରଦିନ ଡେଥ୍ ହେଇକିନି ସେ କୁହାହଉଛି ଗୋଟେ ସନ୍ଦେହ କରୁଛନ୍ତି ଯେ ବୋଧହୁଏ ତାର ବାତ ଫାତ ହେଇଥିଲା, ସେଇଥିପାଇଁ ତାର ହେଇଥିବ। ତେଣୁ that is also creates another suspicion. Then if everything was nobody was aware that what is the why the deceased died, why suddenly this man would come and after 5 days he would make the confession, extrajudicial confession before the villagers. He has done everything cleverly. Let us say it is your case that he has procured the poison very cunningly, without the notice of some. So very cunningly everything he has done. He has left that place, gone to his place of work. Why will suddenly appear and
say confess his guilt?
So it creates doubt because it's a and most important thing is that that very same milk was taken by two of them.
And
There
when the
Maybe that the
my lord has
quantity
gone
would
to
have been
the
a factor.
CW1, my lord.
CW1.
CW1, the court witness, the doctor initially treated. He has referred the
For
treatment,
DHH.
referred, but at the time of receiving that the hospital, they found that he is dead. So in that particular column, he has mentioned that the poisoning matter is that. But even thereafter, the court
suspect poisoning ro se jo pena baharibo, se jo reaction hobo. But unless ଆଉ ଗୋଟେ important ଥିଲା କଣ କି ଆପଣଙ୍କର ଯୋଉ bottle ଟା ଆପଣ siege କଲେ, ଭିସେରା ରିପୋର୍ଟ ରେ ମଧ୍ୟ ସେଇ ପଏଜନିଂ ବାହାରିବାର ଥିଲା। ଆପଣ ଭିସେରା ରିପୋର୍ଟ ଟାକୁ ଆଣିଲେନି ନା, କାହିଁକି ଆଣିଲେନି? ଯଦି ଆମେ ଏଇଆ କହିବୁ ଏଇଥିପାଇଁ ଆଣିଲେନି, ହୁଏତ ତା ଦେହରେ କଣ ଡିଫରେଣ୍ଟ ବାହାରିଥିବ, ତାହେଲେ ଟାଲି କରିବନି। ତେଣୁ ଏଇ ପଏଜନ ୟୁଜ ହେଇନି ତା ଦେହରେ, so he might have died for some other reason. ତେଣୁ ଆପଣଙ୍କର ସେଇ ଯୋଉ ପଏଜନ ଟା ପ୍ରୋକ୍ୟୁର କଲା ଆକ୍ୟୁଜ, ସେଇ ପଏଜନ ଟା ଯଦି ଆ ଦେହରେ ମିଶିଥାନ୍ତା, ଯୋଉଟା କି ଆପଣଙ୍କର କେସ୍, ସେଇଟା ବାହାରିଥାନ୍ତା ଭିସେରାରୁ। ଭିସେରା ଦେଖିଥାନ୍ତା ଯେ ନା ଏଇଟା ଇନସେକ୍ଟିସାଇଡାଲ ପଏଜନ, ଏଇ ସବୁ ଜିନିଷ ଯୋଉ, ତେଣୁ ଏଇଟା ଗୋଟେ ଲିଙ୍କ ଟା ବ୍ରେକ୍ କରି ଯାଉଛି। ଯୋଉ ଲିଙ୍କ ଦରକାର ଆପଣଙ୍କର ଯୋଉ ଚେନ୍ ଅଫ ସର୍କମଷ୍ଟାନ୍ସ କମ୍ପ୍ଲିଟ କରିବା।
That is not there, because the main part is the viscera is not there to know the cause of death.
We are becoming extra careful because the judgment has been delivered by. So that is so we are take down JCRL number 45 of 2008. The appellant Prashant Kumar Maharana faced trial in the court of London Session Judge Puri in ST case number 399 of 2006. for commission of offense under section 302 of the Indian Penal Code on the accusation that on 26/5/2006 at about 5 p.m. in village Brahmana Alandia, he committed murder of Dhaneshwar Maharana, hereafter the deceased. The London Trial Court, by judgment and order dated 19/4/2008, found the appellant guilty of the offense charge and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000 in default to undergo RI for 6 months. The prosecution case, as per the first information report lodged by Pranakrishna Maharana, PW1, before the officer in charge of Chandanpur police station on 31/5/2006 is that on 26/5/2006, Friday, at about 5 p.m., the deceased had been to the house of his maternal uncle, which is situated in the same village, and took milk. And after taking a sip, he, since tasted bitter, he informed the same to his grandmother. After some time, the deceased returned back home, and while ironing his shirt, he also disclosed before his mother, bracketed PW10, about the same, and fell down on the ground, stopped. Immediately, the deceased was shifted in an auto rickshaw to Chandanpur Hospital, where Dr. Rajesh Sahu, CW1, administered one injection to him and referred him to District Headquarters Hospital, Puri. But on the way to the hospital, the deceased died, which was declared by the doctor after reaching the hospital. Communication was made to Kumbharpada police station, so also Chandanpur police station. And on 27/5/2006, postmortem over the dead body of the deceased was conducted in connection with Chandanpur UD, PS UD case number 11/2006. It is further stated that on 30/5/2006, at about 9 p.m., in presence of the villagers, the appellant confessed that he had mixed poison in the milk which was consumed by the deceased, as a result of which he died. This confessional part was communicated by Pavani Maharana,
Hmm.
the father of the
Accused.
appellant,
Accused.
father of the appellant, to his younger brother Manidhar Maharana. On the basis of the first information report presented by PW1, Chandanpur PS case number 57 dated 31/5/2006 was registered under section 302 of the Indian Penal Code against the appellant. With the first investigating officer,
PW9. His name is my lord Umakanto Mohan.
no.
PW?
9.
9. PW
No,
9
no.
is Umakanta Maharana.
Sorry, I'm sorry. PW11, sorry. 11, PW11.
First are you?
Yes, first I. PW11.
Okay.
Bhagavatia Kandho.
As it appears prior to the registration of the case, prior to the registration of Chandanpur PS case number 57 of 2006, after on receipt of the casualty memo from Dr. Kumudini Misra, Medical Officer, District Headquarters Hospital, Puri, the officer in charge of Chandanpur Police Station registered Chandanpur PS UD case number 11 of 2006 and directed PW11 Bhagavatia Kandho to inquire into the matter. And during course of inquiry, PW11 proceeded to District Headquarters Hospital and with the constables and examined the doctor, held inquest over the dead body, and prepared inquest report exhibit 1, and he also examined other witnesses, prepared the dead body challan, sent the dead body for postmortem examination. The postmortem की conduct करा है PW 5.
Yes,
अच्छा. Right.
Dr. Tirthavasi Mahapatra.
PW5, Dr. Tirthavasi Mahapatra, who are the assistant surgeon attached to District Headquarters Hospital, conducted postmortem examination over the dead body of the deceased on 27/5/2006, and he could not give any definite opinion about the cause of death of the deceased. However, he preserved the internal organs of the deceased like spleen, liver, stomach with its contents, and in a sealed bottle, and handed over the sealed bottle to the police constable for sending the same for chemical examination. PW11 received the postmortem report of the deceased, and he also sent the viscera of the deceased for chemical examination to the director SFSL Bhubaneswar, and then submitted the final report. PW12, the officer in charge of Chandanpur Police Station, after registration of the PS case, took up investigation of the case. During course of investigation, he collected the case records of the UD case, and He also visited the spot, prepared the spot map by Exhibit 10, examined the witnesses, arrested the appellant on 1/6/2006 on the basis of the statement of the appellant recorded under Section 27 of the Evidence Act, and on his leading to discovery one
Hildan pesticide container.
one Hildan HILDAN pesticide poison container kept in a blue polythene jerry was seized near a pond which is situated near the temple of Lord Gopinath Dev. As per seizure list, Exhibit 6. The aluminum dekichi alloy as well as a small glass were seized from the house of PW2 in presence of the witnesses as per seizure list Exhibit 7. And the same was sent for chemical examination on 22/6. For chemical examination to SFSL, Director SFSL Rasulgarh. And the C report by Exhibit 12 was 13. Exhibit 13 was obtained. On completion of investigation, finding prima facie case against the appellant, charge sheet was submitted against the appellant. The defense plea is one of denial. In order to prove its case, the prosecution examined 12 witnesses, mention it, and the exhibits number of so and so, then MOs. The trial court examined one Dr. Rakesh Kumar Sahu as CW1. After analyzing the oral as well as the documentary evidence on record, the London trial court came to a finding that on the evidence of PWs 2 and 10, it can very well be said that the deceased consumed the milk, and after consuming, he became serious, and while being shifted to the hospital, he died. It was further held from the after that the evidence of PWs 1, 2, and 10 reveals that the appellant was present in the village and in the house of his grandmother, Sudori, bracketry PW2. It was further held that the nexus of between the poison container MO3 recovered in pursuance to the disclosure statement has been established as the deceased died of similar poison, and it would further show that the appellant had kept the poison container in the place from which the same was recovered pursuant to his disclosure statement. Learned trial court also relied upon the extrajudicial confession stated to have been made by the appellant in presence of PW2 and PW10. And held that the confession is a voluntary one and there was no threat, coercion, or compulsion on the appellant before making confession. And thus the confession of the appellant with regard to mixing the poison with milk, consuming which the deceased died of poison, is acceptable one. It was further held that the appellant had a motive to do harm to the PW2 as the appellant was jealous of the relationship of PW2 with the deceased. The London trial court summed up the circumstances appearing in the case that the deceased died of poisoning, such death of the deceased occurred soon after consumption of milk in the house of PW2, the appellant was present in the said house where the milk was kept on the date of occurrence, pursuant to the disclosure statement of the appellant, the poison container was recovered from a place and the nexus of the poison container with the death of the deceased has been established, and the poison found in the viscera of the deceased was matching with the poison in the container, and that the appellant made extrajudicial confession regarding mixing milk with poison, and that the appellant had a motive to do harm to PW2. It was further held that from the circumstances established by clear, cogent, and unimpeachable evidence by the prosecution, there is no hindrance that it was the appellant who had mixed the milk with poison, consuming which the deceased died, and as such, he contributed to the death of the deceased. Mr. Saugat Das, learned counsel appearing for the appellant, contended that admittedly there is no direct evidence in the case and the case is based on circumstantial evidence. And when it is the prosecution case that the death of the deceased was on account of poisoning, it was required to prove such aspect beyond all reasonable doubt. The doctor who conducted postmortem examination has not given any definite opinion relating to the cause of death and reserved the opinion awaiting the viscera report. When the viscera were sent to the state forensic science laboratory for examination, the prosecutor should have taken steps to procure the same and prove in accordance with law, which has not been done. In a case of this nature, it was also the duty of the investigating officer not only to bring the not only produce the to bring the viscera report, but also to place it before the doctor who conducted postmortem examination to obtain the final opinion relating to the cause of death. The learned counsel further argued that the aluminum dekichi as well as the steel glass which were seized were also sent for chemical examination, and from the same no poison could be detected. The learned counsel argued that the prosecution has also not established the motive on the part of the appellant to commit the crime, and though it is the case of the prosecution that the appellant procured the poison and mixed it with the milk which was kept by PW2, but PW3 being a vital witness to that aspect has not supported the prosecution case. The learned counsel further argued that the extrajudicial confession stated to have been made before PW2 and PW10 cannot be accepted in as much as there are material contradictions between the evidence in court vis-a-vis the statement recorded under section 161 CRPC, which has been duly proved in the case. The learned counsel further submits that extrajudicial confession being a weak piece of evidence, and there is no material corroboration to the same by way of proving the death occurred on account of poisoning, it is very risky to rely on such circumstance. And therefore, it cannot be said that the circumstances have been established, circumstances have been proved by clinching evidence, and that the circumstances form a complete chain which unerringly point towards the guilt of the appellant. And therefore, it is a fit case where the appellant should be given benefit of doubt. Mr. Arupananda Das, an additional government advocate, on the other hand, supported the impugned judgment and argued that the reaction of the deceased after consuming the milk and his disclosure before PW2 is very relevant, and the extrajudicial confession being made by the accused before the close relatives like PW2 and PW10, it should not be disbelieved, and there is also motive behind the commission of crime, and therefore the London Trial Court has rightly found the appellant guilty under section 302 of the Indian Penal Code. Adverting to the contention raised by the London Council for the respective parties, since it is the prosecution case that the deceased died on account of poisoning, we are to first deal with such aspect. The relevant witness is the doctors, that is PW5 and CW1.
Yes.
CW1 was the medical officer of Chandanpur CSC, and he stated that on 26/5/2006, the deceased was brought to the hospital and he was having convulsions, and he referred the patient to district headquarters hospital, Puri. He further stated that since referral slip is not there, he couldn't say what treatment was given to the deceased when he attended him on 26/5/2006. His evidence is completely silent that he even suspected it to be a case of poisoning. The doctor PW5 who conducted postmortem examination stated that he could not detect any external injury on the person of the deceased, and since definite opinion could not be given, he preserved the internal organs of the deceased like spleen, liver, stomach, and its contents and a loop of the intestine and one kidney was kept in the sealed bottle and handed over to the police constable for sending the same for chemical examination. He further stated that the IO made a query to opine as to the cause of death, and he opined that probable cause of death was due to endosulfan insecticidal poison. Admittedly, the evidence has come on record that the viscera was sent to State FSL Rasulgarh for chemical analysis, but no viscera report has been proved in this case. Neither the investigating officer has stated that he collected the viscera report and sent it to PW5, nor PW5 has stated that he received the viscera report and gave his opinion. When at the first instance, the doctor PW5 couldn't give any definite opinion and kept it reserved, awaiting the viscera report, and the viscera report was not produced before him. It is surprising that how he could opine that the probable cause of death was due to endosulfan insecticidal poison. The finding of the Lennon trial court that it's a case of poisoning is not acceptable to us. The material witnesses in this case that is PW2 and PW10 are next to be discussed. PW2 is none else than the grandmother of the appellant, and she has stated that the appellant is the son of her adopted son Pabani, and the informant is our son-in-law. She further stated that she had a tremendous liking for the deceased, as he was reading well, and whenever the deceased was coming to his house, she used to take care of, or to her house, she used to take care of him, for which the appellant was jealous on the deceased, and sometimes the appellant was also misbehaving with her. PW2 further stated that the appellant, the deceased, had come to her house on Sabitri Amavasya day, and the appellant had also come on that day. And the parents of the appellant had gone to the temple, and when the deceased arrived at her house, she inquired from him whether he had taken anything, and when he told that he had not taken anything, she gave him milk by bringing the same from the pot. She further stated that the deceased, after taking a sip of the milk, complained that it was tasting bitter, and inquired from her whether it was mixed with kerosene or petrol. And after washing his mouth, the deceased returned back to his house. She further stated that when the deceased took the milk, the appellant was present in the house, and after the deceased left the house, the appellant also followed him. She further stated that she also tasted the milk and found the same emitting bitter smell, and she also gave a little milk to her daughter-in-law, Radhamani, bracket PW10, who also complained that the milk tasted bitter.
Radhamani has been examined.
Say Mani mane Radhamani.
That is exactly. That is what.
The She further stated that the milk was procured from one Aparti, and she went she went to the house of Aparti.
Daughter-in-law.
Daughter-in-law Radhamani. Radhamani হচ্ছে PW10.
Doctor is the PW10. Radhamani doubt also same Mani Radhamani mean
Radhamani is the daughter-in-law. Mani is the mother of the
Yes.
mother of the deceased.
Yes.
That's here.
Exactly.
Daughter-in-law Radhamani করবে
So doubt is not a
She has,
Radhamani.
no, she has not been.
আচ্ছা
He has not
PW10 টাও কাটি দিও. All right. And inquired from Aparti, who informed her that he had supplied the same milk in 2 to 3 houses. And he also gave the milk to PW2, which did not taste bitter. PW2 further stated that while returning to the house, he poured the rest of the milk which she had kept in the container in the waters of Linga Pokhari, and the fishes of the said pond died. The PW2 further stated that on the next day of the death of the deceased, the appellant returned back to Puri to join his service, and again returned back to the house 5 days thereafter. And in that night at about 9 p.m., her presence, also in the presence of others, he confessed to have mixed poison to the milk which he had kept in the container to kill the deceased. as the deceased was reading well and PW2 had tremendous liking for the deceased. She further stated that she had washed the container in which she had kept the milk, so also the glass. In the cross-examination, PW2 has stated that she had given a little than half a glass of milk to the deceased to drink, and the deceased drank half of the milk given to him, and after taking a sip, complained of bitter taste and did not drink any more. And after keeping the glass with the rest of the milk, complained smell of petrol and kerosene in the milk and left the house. The evidence of PW2 reveals that after the deceased complained, taking a sip of the milk, not only she but also her daughter-in-law Radhamani tasted the milk, and they also found that it was bitter. But there is no evidence that there was any reaction after taking the milk by either PW2 or by Radhamani. If Radhamani has not been examined in this case, if the same milk was taken by not only the deceased but also by PW2 and Radhamani, and nothing happened to them, and no viscera report was produced, and the opinion of the doctor, bracketed PW5, without perusing the viscera report, that it is a case of poisoning, probable, it's a case of probable causes poisoning. The doubt is created as to whether poison was mixed with the milk in question or not. In a case of this nature, not only the source of procurement of poison was required to be established by the prosecution beyond all reasonable doubt, but it was also the requirement to prove the viscera report so that it could have been established that the container, the diba, the tin diba from which the endosulfan and insecticidal poison was detected on chemical analysis, was also found in the viscera. Therefore, the a doubt is created that poison was mixed with the milk which was administered by PW2, which was given by PW2 to the deceased, as a result of which there was a reaction to the deceased and ultimately he died. Coming to the extrajudicial confession, though PW1 has stated, PW1, the father of the deceased has stated in that respect, but in the cross-examination, he has stated that after 5 days of the death of the deceased, the confession was made by the appellant, which he learned from Pabani, his brother-in-law. The said Pabani has not been examined in this case. Therefore, it appears that PW1 has no direct knowledge about the extrajudicial confession. Coming to the evidence of PW2, though she stated that 5 days after the occurrence, the appellant confessed before her as well as before the others who have mixed poison to the milk which she had kept in a dekichi to kill the deceased, as the deceased was reading well and C PW2 had tremendous liking for the deceased, but it has been confronted to the previous statement of PW2 was confronted to her, and it has been proved through the investigating officer PW11. Sorry, PW12. PW12. That she did not state before the IO that the appellant had confessed before him and others to have mixed poison to the milk which she had kept in a dekichi to kill the deceased, as the deceased was reading well and as she had tremendous liking for the deceased. And that PW2 did not state before the IO that the appellant confessed before them and the villagers that he had mixed insecticide poison to kill her PW2 and the deceased. And she has also not stated that the deceased after a complaint that kerosene and petrol have been mixed with the milk, and after washing his mouth he left his house, and that the appellant followed him. In view of the material contradictions in the evidence of PW2, it is very difficult to accept our evidence so far as the extrajudicial confession part is concerned. The other material witness on behalf of the prosecution is none else than PW2, who has stated that with the mother of the deceased and stated that the appellant was her nephew, bracket brother's son, and her mother had adopted the father of the appellant. She further stated that on the Savitri Amavasya day, that is 26/5/2006, in the evening hours, the deceased proceeded to the house of PW2, and half an hour thereafter, the deceased returned to the house, and while ironing one of his pant, he complained reeling of head and called her. And when she inquired from the deceased about the cause of head reeling, the deceased disclosed that after drinking milk in the house of PW2, from which smell of petrol and kerosene was coming, it was tasting bitter, and then the deceased vomited and lost his sense, and she rushed to the house of PW2 to know as to what milk PW2 had given to the deceased to drink. And she found the appellant was present there, and was very much perturbed. And the PW2 disclosed before her that the deceased was complaining taste of bitterness while drinking milk, and hardly he had taken 2 sips and refused to drink the rest of the milk. This witness has also stated that in the evening of 30/5/2006, the appellant arrived in the house, and in presence of others, he confessed that he had mixed Hiladin pesticide in the milk to kill the deceased and PW2, which he had purchased, and that he purchased the poison from Chandan Bazaar 20 days prior to the occurrence. It has been the previous statement of this witness has also been recorded under section 161 CRPC, has also been confronted, and it has been proved through the investigating officer PW12 that she has not stated that on 30/5/2006 evening, the father of the appellant came to their house and called her to his house, and thereafter she, along with her brother-in-law, proceeded to the house of the appellant. And she has also not stated that in the evening of 30/5/2006, they arrived at the house of PW2, and found PW2 and Bhaskar Mudeli present there along with the appellant, and she has also not stated that in their presence the appellant confessed to have mixed poison in the milk to kill the deceased and PW2. She has also not stated that the appellant confessed before them that he had purchased Hildan poison to kill the deceased 20 days prior to the occurrence from Chandanpur Bazaar. Therefore, there are material contradictions in the evidence of PW10 so far as the extrajudicial confession part is concerned. And since a statement is made for the first time in court, it is very difficult to be accepted. Admittedly, in the statement made by the appellant, by the deceased before PW10, nothing has been stated against the appellant. It is only stated that after drinking milk in the house of PW2, it tasted bitter, for which there was vomiting. In absence of any clinching evidence that if the stop. Law is well settled that extrajudicial confession is a weak piece of evidence. The court must scrutinize all the relevant factors, such as person to whom the confession is made, the time and place of making it, the circumstances in which it is made, and finally, the actual words used. The court is also to be satisfied that it is voluntary and it does not appear to be the result of inducement, threat, or promise as contemplated under Section 24 of the Evidence Act. In the case in hand, though both the witnesses who have stated about the extrajudicial confession are closely related to the appellant, but when it is the prosecution case that the appellant has planned for committing the murder of the deceased as well as PW2, and accordingly he procured poison and secretly mixed with the milk which was kept by PW2, and nobody was aware about the same, then why after 4 to 5 days of the occurrence, he suddenly came forward and disclosed before others who have mixed the poison in the milk? Admittedly, as already stated, there is no evidence on record that poison was mixed in the milk. The inquest was conducted on the next day of occurrence, and in the inquest report, by Exhibit 1, which was prepared in presence of PW1, the father of the deceased and others, it was mentioned that the probable cause of death was on account of epileptic fits. If on the date of occurrence itself, the deceased has stated before PW10 that he took milk in the house of PW2, it tasted bitter and was smelling kerosene and petrol, and there was any reaction to him, and he subsequently died. This could have been reflected in short, at least in the inquest report, particularly when PW1, the father of the deceased, was a witness to the, which is signatory to the inquest report. The inquiry officer, that is PW11, who conducted the inquiry from 27/5/2006 till 1/6/2006 and examined a number of witnesses, has stated that he did not get any information till he submitted the final form regarding the involvement of the appellant in causing the death of the deceased. Rather, the PW1, the father of the deceased and others disclosed before him that the deceased died of epileptic fits. And that is how PW11, while preparing inquest report, has mentioned the same in column number 9 of the inquest report. The Lenin trial court while summarizing the circumstances, has made an observation that the poison found on the viscera of the deceased matched with the poison in the container. When the viscera report was not produced and not proved in the case, not placed before the doctor, it is for opinion. It is strange that how such an observation has been made by the Lenin trial court. Law is well settled that when a case is based on circumstantial evidence, the prosecution is required to prove each of the circumstances by clear evidence and the circumstance cannot be explained under any other hypothesis. The circumstances taken together must form a complete chain from which there would not be any escape from the conclusion that it is the appellant and appellant alone who has committed the crime. In the case in hand, when the prosecution case that it is a case of poisoning has not been established by adducing cogent evidence, and in the so-called dying declaration stated to have been made before PW 10, the deceased has not whispered anything against the appellant, and the source of procurement of the poison has also not been established. The extrajudicial confession part is not believable on account of material contradiction. We are of the view that it is very difficult to rely on the prosecution evidence to come to a finding that it is the appellant who has committed the murder of the deceased. We are of the view that the finding arrived at by the London trial court is not sustainable in the eye of law. In the result, the jail criminal appeal is allowed. The conviction of the appellant under section so and so is hereby set aside. The appellant is on bail. You are not aware. এই দেখিল তার রেকর্ডটা দেখি। Bail হয়েছি? All right. It appears that the appellant was released on bail as per order dated 27/7/2012. The bail bond and the surety bond stands cancelled. Put a note of appreciation on the efforts of both the London Council. We'll see on the matter. This is not in today's list.
Supplementary list item number 2.
And 16. This file was missing, and we have got it. Let it come next week so that it will be had.
There is some order passed by the Honorable Supreme Court.
Yes. Next week, my lordship.
What is the order? Supreme Court order.
However, the petitioner is at liberty to approach the High Court for early disposal of the appeal.
No, any time limit has been.
No, my time limit has not been. This is the order.
Please pass on. In 2018.
Yes.
No, why it suddenly came, matlab, in supplementary list? Why? Shall run council appealing for so and so. Is to add to the matter. Written note submission has already been filed. No, it's all right. Just let us begin, Mr. Das.
Yes.
Let her begin. You ask her to remain present.
Yes,
Take note of it.
Yes, ma'am. Yes.
Yes.
My lord, here in this case, the appeal arising out of the judgment passed in Special Judge Vigilance Sambalpur in CTR case number 21 of 2004, my lord. Arising out.
You come to the FIR.
My. There is running.
The council is on.
Yes, ma'am. Council is available. Item 1.
Pattern matter is coming. It of a suppose in as soon as the rate of Rakidio. So pattern matter is coming. Please come. No, that one.
Kindly bring in the supplementary.
It will come next week, ma'am.
Fine. Oh, bless.
She also will go through it.
Oh, bless.
Way of lodging the FIR, Your Lordship.
Come to the FIR, let us see.
Lordship, page 44 of the paper. Lordship.
Yes.
As for the FIR, Lordship, the date of occurrence was 26/2/1997, Your Lordship. And the FIR was lodged on 16/3/1997. After 17-18 days after, Your Lordship, of the occurrence. PW1 is the informant, Your Lordship. May I read your FIR, Your Lordship?
Yes.
ନିବେଦନ ଏହିକି ଆମ୍ଭେ ଶ୍ରୀମତୀ ସ୍ୱପ୍ନାରାଣୀ ସେନାପତି ସ୍ୱାମୀ ମନୋଜ ସେନାପତି ସୁଅଂଶୁ ବାଲେଶ୍ୱର ଆଜି 15/3/97 ରିଖ ଆପଣଙ୍କ ଥାନାରେ ଉପସ୍ଥିତ ହୋଇ ନିମ୍ନଲିଖିତ କାରଣ ପ୍ରତି ଆପଣଙ୍କ କୃପା ଦୃଷ୍ଟି ଆକର୍ଷଣ କରୁଅଛୁ। ମୋର ସ୍ୱାମୀ ମନୋଜ ସେନାପତି ଓରଫ ଶମ୍ଭୁ ସେନାପତି ଘରେ କାମ ଦାମ କରୁନଥିବାରୁ ମୋର ଶାଶୁ ଶ୍ୱଶୁର ଓ ଦେବର ମାନେ ମୋର ସ୍ୱାମୀଙ୍କୁ ଅଧିକାଂଶ ଦିନ ମାଡ଼ ଦେଉଥିଲେ। ଗତ ତା
से मनोज सेनापति किए?
The deceased, your lordship. 26/2/97
सासू किए?
कौशल्य सेनापति, your lordship.
Appellant number 2.
Yes, your lordship.
ससुर?
ससुर हेले पदवेंद्र सेनापति, appellant number 1.
And 3 is the
He is the brother of the deceased.
brother-in-law.
Brother-in-law of the informed, brother of the deceased.
Okay. Yeah.
ଶାଶୁ ଶ୍ୱଶୁର ଦେବର ମାନେ ତାଙ୍କ ଉପରେ ବିରକ୍ତ ହେଉଥିଲେ। ସେଇଦିନ ମୁଁ ସକାଳେ ଶାଶୁ ସହିତ ସୋରିଷ ଉପାଡ଼ି ଯାଇଥିଲି। ମୋର ଶ୍ୱଶୁର ହଳ କରିବାକୁ ଓ ଦେବର ବଜାରକୁ ଯାଇଥିଲେ। ଦିନ 9ଟା ବେଳେ ଘରକୁ ମୁଁ ଫେରିବା ପରେ ମୋର ସ୍ୱାମୀ ମନୋଜ ଉଠି ଆସି ଖାଇବା ପାଇଁ ରୋଷେଇ ଘରେ ଚାବି ପଡ଼ିଥିବାରୁ ଚାବି ଝିଙ୍କା ଝିଙ୍କି କରି ଖରାପ କରିଥିଲେ ଓ ଚାବି ଭାଙ୍ଗି ଘରେ ପଶି ଖାଇଥିଲେ।
मनोज होची
Deceased, your lordship.
अच्छा हाँ deceased हाँ
ଘରେ ପଶି ଖାଇଥିଲେ। ମାତ୍ର ମୋର ଶାଶୁ ଧମକ ଦେଇ କହିଥିଲେ କି ଆଜି ତୋର ମରଣ ହେବ, ତୋର ବାପା ଫେରି ଆସୁ। ମୋର ସ୍ୱାମୀ ଘରେ ଶୋଇଥିବାର ଦେଖି ମୁଁ ମଧ୍ୟ ଦିନ 2:30 ବେଳେ ପୁଣି ମୋର ଛୋଟ ନଣନ୍ଦ ସହିତ ପାଳକୁ ସୋରିଷ ଉପାଡ଼ିବାକୁ ଚାଲିଗଲି। ସନ୍ଧ୍ୟାବେଳେ ଫେରି ମୋର ସ୍ୱାମୀ ଶୋଇଥିବା ଘରେ ଚାବି ଦିଆଇଥିବା ଦେଖି ଘର ଖୋଲିବା କହନ୍ତେ ମୋର ଶାଶୁ ଶ୍ରୀମତୀ କୌଶଲ୍ୟା ସେନାପତି ମନା କରିଥିଲେ ଓ ଚାଉଳ ଇତ୍ୟାଦି ବାହାର କରି ଆଣି ଚୁଲି ମୁଣ୍ଡରେ ରଖିଥିବାର କହି ମୋତେ ରୋଷେଇ କରିବାକୁ କହିଥିଲେ। ମୋ ସ୍ୱାମୀ କୁଆଡ଼େ ଗଲେ ମୁଁ ପଚାରିଲେ ମୋ ଶାଶୁ ଶ୍ୱଶୁର ମାନେ କୁଆଡ଼େ ଗାଁ ଆଡ଼କୁ ଶମ୍ଭୁ ଯାଇଛି ମିଛରେ କହିଥିଲେ। ରୋଷେଇ ସାରି ଖିଆପିଆ ପରେ ମୁଁ ଶୋଇଲି। ମୋ ଶାଶୁ ମୋର ଶୋଇବା ଘରେ ଦ୍ୱାର ମୁହଁ ପାଖରେ ଶୋଇଥିଲେ। ରାତିରେ ମୋର ଶ୍ୱଶୁର ଓ ଦେବର ମାନେ ମୋର ସ୍ୱାମୀଙ୍କର ଚାବି ଖୋଲି ଘରୁ ବାହାର କରି ବାହାରକୁ ନେଉଯାଉଥିବା ମୁଁ ଉଠି ପଡ଼ି କାନ୍ଦିବାରୁ ମୋ ଶାଶୁ ଶ୍ରୀ ପଦବେନ୍ଦ୍ର ସେନାପତି ଓ ଦେବର ସର ସେନାପତି ମାନେ ମୋତେ ଧମକ ଦେଇ ଜୀବନରୁ ମାରିଦେବେ କହିଥିଲେ ଓ ଏ କଥା କାହାକୁ କହିଲେ ଜୀବନରୁ ମାରିଦେବେ କହିଥିଲେ। ମୁଁ ସବୁ ଦିନ ଶାଶୁ ଶ୍ୱଶୁର ଦେବର ମାନଠୁ ମାଡ଼ ଖାଇ ଭୟାତୁର ହୋଇ କାହାକୁ ଘଟଣା ସମ୍ପର୍କରେ ଏପର୍ଯ୍ୟନ୍ତ କହିନଥିଲି। ମୋର କାକା ଶ୍ରୀ ରବୀନ୍ଦ୍ରନାଥ ଦାସ ନାଳିରେ ଗୋଟିଏ ପିଜୁଳି ଗଛ ମୂଳରେ ସନାତନ ସିଂ ଶବ ଦେଖିବାରୁ ମୁଁ ଚିହ୍ନିଥିଲି ତାର ମୋ ସ୍ୱାମୀଙ୍କର ଶବ ରହିଥିଲା। ସେଇ ଦିନଠାରୁ ଜୀବନ ଭୟରେ ମୁଁ ନୀରବ ରହିଥିଲି। ମାତ୍ର ମୋ ଶାଶୁ ଶ୍ୱଶୁର ଦେବର ମାନେ ମୋ ସ୍ୱାମୀଙ୍କୁ ମାଡ଼ ମାରି ଜୀବନରୁ ମାରିଦେଇ ଘରେ ପକାଇ ଚାବି ଦେଇ ରଖି ରାତିରେ ଶବକୁ ନେଇ ମହାବିଲାରେ ପକାଇ ଦେଇଥିଲେ। ତହିପରେ ସକାଳ ମୋର ଶାଶୁ ସେଇ ଘରେ ଚାବି ଦେଇ ଘର ପରିଷ୍କାର କରିଥିଲେ। ମାତ୍ର ମୋର ବାପ ଘର ଗ୍ରାମର ଲୋକମାନେ ଯେ ବରଣ ଫଳରେ ମୁଁ ଘଟଣା ପ୍ରକାଶ କରି ଆଜି ଆପଣଙ୍କ ଥାନାରେ ଜଣାଉଛି ଉପରୋକ୍ତ ଆସାମୀମାନେ ସ୍ୱାମୀକୁ ପିଟି ପିଟି ମାରିଛନ୍ତି।
So this lady is PW1.
Yes, Lord.
Come to the evidence of PW1. Let us see.
I know the accused person. They are my mother-in-law, father-in-law, and brother-in-law. My husband died 2 years back in my matrimonial house. These accused persons have killed my husband. After my marriage, I was staying in my matrimonial house. On the previous day of his death, which was a Tuesday, my husband asked for food to his sister. She told that she would not give food for him. Throughout the day, she was made to starve, and in the evening only he took some bhuja. His parents, brother and sister were assaulting my husband and did not allow him to take food. And these accused persons were also assaulting my husband. As my husband took bhuja in the evening on that day, accused Kaushalya, who is my mother-in-law, abused my husband, and in the night also the accused person did not give food to him. I also did not take any food in the night. On the next day, that is Wednesday in the morning at about 7:30 a.m., after I finished my work, my mother-in-law sent me to uproot mustard plants from the land which was at a distance from my house. Accordingly, I went to that field at about 9 to 10 a.m. I returned back from the mustard field. At that time, my husband asked for food to me. By then, the kitchen was locked. I told my husband that the key was not with me, so I could not give food to him. My husband then told me that he had not take any food. So saying, he dragged the lock and opened it. He went inside the kitchen and took food. Thereafter, the accused Kaushalya abused my husband, uttering, "Tor aji marana hebo to bapa asu." Then in the afternoon, my mother-in-law sent me along with my nonanda sister-in-law to uproot mustard plants in the mustard field. When we returned back, I found that our Baithak-khana was locked. Then I asked my mother-in-law to open the door so that I will clean the room. Then my mother-in-law replied that she had already cleaned the room and asked me to clean the other parts of the house. Then I cleaned the other part of the house. Then I asked my father-in-law about the whereabouts of my husband. He replied that my husband had gone inside the village. Then it was night. Both my parents-in-law asked me to take food and sleep. I told that after my husband returned, we will take food. Then I went inside my bedroom, and my mother-in-law also spread her bed at the doorway of that room and slept there. Then I asked my mother-in-law as to why she should sleep in my bedroom in that night. She replied that I might get fear by sleeping alone in the bedroom. So she wanted to sleep there. In the dead of the night, my mother-in-law came out of that room by slowly opening the room. By then I was not asleep, and I was waiting anxiously for my husband. Then I came out of that room and saw my mother-in-law standing at the doorway of the Baitakhana, which was locked up. Then I found accused Padavendra Senapati and Saroj Senapati, who were father-in-law and brother-in-law respectively, were bringing the dead body of my husband from that Baitakhana. Seeing this, I started crying. Then my mother-in-law gasped my mouth by putting her hand. Then accused Saroj rushed at me holding a knife and threatened me if I disclosed it before anybody, then he could kill me. Thereafter, I lost my senses. When I regained my sense, I found myself sleeping in my room. On the next day morning, my mother-in-law sent me to mustard garden forcibly. After I returned from the mustard garden, I found that the Vaitakhana was cleaned by mud and cow dung. After 15 days of the date of the occurrence, I lost the FIR at the police station. I was frightened by the accused as well as I lost my balance of mind due to the death of my husband. The delay in lodging a FIR in PS. I submitted the written report at the police station scribed by my uncle Rabindranath PW2 as per my instruction. That is cross examination. I only gave my statement before the magistrate at Jaleswar. I have not filed any petitioner affidavit. I went to Jaleswar court. My uncle had gone with me. I don't know what is affidavit. 4 to 5 days after the death of my husband, I saw his dead body in the paddy field. I came from my matrimonial house to the paddy field, saw the dead body of my husband. Therefrom, left for my parents' house. My uncle Rabindra called me when I was in my matrimonial house and see the dead body of my husband in the field. Then I accompanied him to that spot, saw the dead body of my husband and left for my parents' house. It is not a fact that I stated before the IO that my uncle Rabindra called me to parents' house saying that my father was ill and that when I was in my parents' house. I got information that a dead body was lying in the paddy field, and then I come to their field with my father and identify dead body of my husband in the paddy field. On that day, my uncle Rabindra informed about into the police. Police came and interrogated me in the same day night. At that time, I had lost my balance of mind. It is not a fact that I have stated before the IO that in that night, that is Wednesday night, I slept in the night and wake up in the early morning. It is a fact that in the UD case, fast after the dead body was recovered, a UD case was registered. In fact, in the UD case, I have not stated before the police that I saw my mother-in-law standing on the doorway of the Vaitakhana, my father-in-law and brother-in-law bringing the dead body of my husband from that room. When I cried, my mother-in-law gasped my mouth, and that my brother-in-law rushed at me holding a knife, threatened me to kill. I have not stated these things before police out of fear, as he showed a knife to kill me if he disclosed. She doesn't told the police in the UD case investigation. After I left my matrimonial house with my uncle, I have not returned back to that house. On the recovery of the dead body, she left with her uncle to his matrimonial house, Your Lordship. There is no part of fear to lodge a FIR to tell the police about the incident or his family members.
No, you have threatened. Why? You have threatened. She was frightened.
The threatened part, Your Lordship, on 2/3/1997, the dead body was recovered.
She was threatened, frightened. Knife was shown to her, and that is her consistent evidence.
Yes, that part, Your Lordship, till 2/3/1997.
Yes.
After the dead body recovered on 2/3/1997, he was permanently go to his
If you don't disclose before anybody,
yes,
so
Lord.
it would take a time to obviously to lose the FIR. So why that statement would be disbelieved?
Neither police, neither told his parents also about this incident.
No, somebody has been threatened that fear psychosis, how a person would react and how much period would be there. So it depends upon person to person. It's not any straight jacket formula that every person would, in spite of the threat, they would disclose it within 1 or 2 days. It may take some time, and even like in sexual offenses also, They take time. The victim made delayed disclosure. The parents then, after coming to know also, they think that whether to report or not. Prestige of the families. Here this it's none else than she has seen all this horrifying incident happened in her presence in the dead hour of the night, and she was threatened by all her in-laws family members. On the one hand, she has lost her husband. The other hand, she was threatened by the in-laws. Now, in that, not to disclose before. So she was. It's all right that police had inquiring in the matter, but depends upon that.
After he going to his parental house, there is no part of fear, Your Lordship.
No.
FIR was lodged on 16/3/1997, and he went to his parental house 2/3/1997, Your
So
Lordship.
that part, my lord, PW2 and PW4, the father and uncle of the informant, they have stated after returning to their house also, she was senseless, and he was
Obviously, the
My lord.
husband has died. She has seen the dead body. So,
and that to the behavior of the mother-in-law and father-in-law and daughter. Mother-in-law came and slept with the
says,
informant.
what would be her state of mind?
My lord.
Nobody knows it. A lady has lost everything.
Yes,
Her husband is gone, and he was murdered, and dead body was removed soon. So it would be a
and that
shocking
too, my
affair.
lord,
The
this
murder part is
UD
not
case
there, Your
also
Lordship.
registered, missing report was given by the informant's father,
Hmm.
not by the family members, Your
Hmm.
lords. He was missing for 4-5 days, but not a report
Missing
was
report
given
is
by
not
them.
there.
Missing report they have not filed.
Hmm.
After the dead body found, UD case was lost.
Hmm.
And FIR was also lost by this person. And at the time of receiving of that body, my lord, the accused were present there.
Hmm.
They went to that spot, saw that this is the son, this admitted, and thereafter they flee from, absconded from that place, my lord, also. That time FIR was not lost, but still then they absconded from that place. And they've been arrested later of man. And there was ill feeling between them.
He's only harping on that delayed disclosure.
Yes, sir. And
So-
interestingly, my lord, DW1, a affidavit was filed. Your lordship, kindly have a glance to that affidavit.
Hmm.
DW1.
No, when the dead body was found,
After 4-5 days, man.
Okay.
Of that occurrence. And PW2, the uncle, when he had gone to his house, also the mother-in-law said that he's suffering from some disease, that is why he had gone for puja also.
The mother clearly stated that he has went for 10-15 days for outing, Your Lordship. Irregular.
PW2 has stated in page 83. When I asked mother, she told that Manoj had left since 3 to 4 days and had not returned. Then I asked as to where Manoj had gone. She replied that Manoj was ill and he was telling to go a temple for Adhya, and he might have gone there to some relation's house, and she also told me to search for him. Then I returned home and told this to my brother. On the next day, which was a Saturday, my brother went to search of Manoj. He did not return back home on Saturday. On Sunday, he came and told that he could not trace. On the same day, subsequently getting information that a dead body was lying in Maha
Bilnola.
Myself, my so and so, found the dead body of Manoj there. The Nala inside the paddy field. Then I left the house of so and so. Then I brought PW1 to show the dead body of Manoj. She came, saw the dead body, and did not return back to her matrimonial house. Came with me to her parents' house. Then myself and my brother went to so and so. In the night, police came, guarded the dead body. PWS, this one. PW1 was always crying in her parents' house and was also becoming senseless at times. The police asked us to bring PW1 to the police station for this case. I told that Police that she was always weeping and also becoming senseless, as she could not be brought to the police station at that time. Police advised to bring her after some days. Then after some days we took police station. At the police station, PW1 narrated the incident before me, which was reduced to writing and read over, admitting the same to be correct to the signature. So,
same statement given by PW for the father also, my lord. An interesting lordship, kindly have a glance to DW1.
I would keep PW2
Four.
PW4 is the father of the informant.
Father of the informant.
এটা जो प्लेस ला এটা ला
Two.
PW2
Uncle of the informant.
uncle of accused
Informant.
Uncle of the informant.
PW4 के
The father
of the informant.
father-in-law of deceased.
PW1 is my daughter. I know this one. So that's something proper. Dead body gala. I learned that dead body. Then I sent Rabindra to bring the accused to bring PW1. Same thing. PW1 brought PW. Rabindra brought PW1 to that. She also saw the dead body of the. Seeing it, he lost his balance of mind. Then I brought her to my home and reported the matter to police station. Police arrived at the spot, was the dead body in the night. They inquest over the dead bodies and the dead bodies once. I was asking PW1 as to how Manoj died or swan so. He was unable to tell anything, out of shock, and she lost her balance of mind upon swan so. So explanation has been given.
Yes. Lodging delay of the affair, expression.
And what about DW1 you said?
He has filed an affidavit. In the
What
court
affidavit?
that they have not done any wrong, this present appellant manner. I have identified, shall I place it, madam?
Yes.
I have identified Swapna Rani Senapati, who had sworn an affidavit on 16/1/19. The advocate clerk Ananta Raut had scribed the affidavit. When I was not present, I have attested the LTA Swapna Rani and that I read and explained content of the affidavit to her. I have not filed this affidavit in the court. Swapna Rani admit the contents to be correct before me and in my presence. In that the cross-examination part.
Yes.
In this, I did not know Swapna Rani Senapati before the date I attested her LTI. Anant Raun is the clerk on the
point
ये से कହୁଛି ଯେ ସେମାନେ case ମାନେ ସେମାନେ ମାରି ନାହାନ୍ତି I have
ସେ
given
ଗୋଟେ
a false
affidavit ହେଲା
case.
ସେମାନେ ମାରି ନାହାନ୍ତି ବୋଲି ଏମାନେ ନିର୍ଦୋଷ।
And I am giving this a false case I have given. But that affidavit was false for me. The DW1 cross-examination it is.
किए मारना थी कौन
ये जो
Present
appellant
appellants.
and this lady filed a affidavit before, and that is where they called him as DW1 to that advocate man. And in cross-examination, he clearly stated that it is a fake one. It reveals.
This lady PW1 कौन करे?
कहला जो एमाने मारी नाहंती, I had given a false case.
वो जो informant का था।
माइला informant given a false informant ର affidavit है।
नहीं informant पर examine है जी PW1 को पुणी तो DW1 कौन?
नहीं DW1 ଗୋଟେ ମାନେ PW1 filed an affidavit, sworn an affidavit before this law. The DW1.
DW1 is an advocate.
My lord. Thereafter, in cross-examination, he admitted this is a fake affidavit. She has not gone to her.
No, at least that affidavit should have been confronted to the relevant witness, that is PW1.
Yes, ma'am.
That ତମେ ଏମିତି ଫାଇଲ କରିଥିଲ ଏବଂ ତମେ ସତ୍ୟ ପାଠରେ କହିଥିଲ ଯେ
she has stated no, madam. To that effect, PW1 confront ହେଇଛି।
ମୁଁ ତ ଆଉ
ନାଇଁ। So from this, the intention of this accused man, their conduct, your lordship, that is why I place that man. There was ill feeling between them. PW1 has stated that was not In cross-examination, they have not bring it out. And there no missing report was filed by these appellants. Thereafter, ill feeling between them, my lord, and filing of the and last scene they were together by PW1.
Entire conviction
these are
surrounding
the
before the
things-
statement
these
of the
are the
PW1.
things there, my lord. These are the things there. But still, then, though, because this PW5 found that the dead body was rotten, and whether it is homicidal or not, couldn't
And he
verify.
clearly stated that
So
there is
that is why
no bodily
convicted-
external injury or lordship.
So that is why you are acquitted of the
Yes,
charges.
Yes,
and
Your
201 the खाली conviction है. To that effect, my lord, I was searching of judgment. I did not find any judgment that only on 201 because statute is very clear on that part. That you cannot convict a person. So 201 I had gone through my last occasion also, and I did not find any judgment. But there is judgment. If 5 accused are there, 3 of them convicted for 302 or 1 of them convicted for 302, then 201 can be possible for others, those who are found with the ingredients of 201. But solely on 201,
But there are decisions that 201 conviction can be made even if the accused is acquitted. 20, take down the decision. It's 2007, volume 7, Supreme Court cases 502, where it is stated that notwithstanding the acquittal of Bhar Karasin. Come here. SEC खोले ଆସିବ लॉगिन करो type 2007, volume is 7, SCC page होची 502.
Sukhram judgment provided.
502, volume 7 ठीक है जी SCC पर होगा 502 what you have to
Sukhram judgment.
I thought click करो state citation paragraph 16, 22 and 23 are relevant. Yeah. Thousand seven SCC 502 Sukhram versus State of Maharashtra. Paragraphs are 16, 22, 23. Let us see. Bearing in mind this factual and legal backdrop, we are of the opinion that the High Court was not justified in convicting the appellant having committed a major offense punishable under Section 302. Nonetheless, it is well settled that notwithstanding acquittal of the said appellant for the offense under Section 302 IPC, his conviction under Section 201 IPC is still permissible. That is the Constitution Bench decision of Kalavati versus State of HP. Kalavati versus State of HP. Therefore, the question that remains to be examined is regarding correctness of the conviction of appellant number 2 for the offense under Section 201. And 201 has been quoted. The first paragraph of the section contains the postulate for constituting the offense, while the remaining 3 paragraphs prescribe 3 different types of punishment depending upon the degree of offense in each situation. To bring home an offense under Section 201 IPC, the ingredients to be established: committal of an offense. Person charged with the offense under Section 201 must have the knowledge or the reasons to believe that an offense has been committed. Person charged with the said offense should have caused disappearance of evidence. And 4, the act should have been done with the intention of screening the offender from legal punishment, or with that intention that he should have given information respecting to the offense which he knew or believed to be false. It is plain that the intent to screen the offender committing an offense must be the primary and sole aim of the accused. It hardly needs any emphasis that in order to bring home an offense under Section 201 IPC, a mere suspicion is not sufficient. There must be on record cogent evidence to prove that the accused knew or had information sufficient to lead him to believe that offense had been committed, and that the accused caused the evidence to disappear in order to screen the offender, known or unknown. Then paragraph. Okay. In the present case, indubitably there is no eyewitness to the and prosecution has sought to establish the case against the appellants from the circumstantial evidence. It is tried to say that in a case based on circumstantial evidence, so and so. Okay. In the present case, motive as a direction. 22. The sole reason given by the High Court for holding appellant number 2 guilty under 202 is the circumstance flowing from the evidence of PW2, wherein she had stated that accused 1 and so on were sleeping in one room and we were sleeping in the other room. Undoubtedly, it meant the mainstay of the prosecution case was the statement of PW12. There is absolutely no other evidence of circumstance attributing to PW2 appellant number 2 the knowledge of commission of the in respect of his daughter-in-law, Mirabai, merely because he happened to be the father of the appellant, cannot be presumed the matter. We have legal proof that he must have deemed to have knowledge of the offense committed by his son. Even if this witness was declared hostile, had been cross-examined by the prosecution near Presenson. All right. So it can be done, but it depends upon case to case. Now, if we see the ingredients of the offense, Then that an offense has been committed. So offense has been committed means it's a case of homicidal death. So whether the prosecution has proved that it's a case of homicidal death.
No, your lordship.
No.
Where is the finding?
Finding is on para 29, my friend. Para 29, page 37 of the
37.
So if this is the finding that the death of the deceased was homicidal, এইটা যদি মানে আসিলানি তাহলে there is no material that there is a commission of an offense.
And I had gone through that CHRI judgment, my lord, referred now. But it is a different case. But what I pray, my lord, reading the PW1, PW2, and PW4, my lord, it's a doubt creates in the mind that definitely.
On the doubt, suspicion, doubt,
suspicion
these
is
are not
there.
the material. So
It cannot be convicted on
maybe
201.
you see, somebody, suppose their son has died in other way, not a homicidal way, but on the other way. They are suspecting that if you will keep the dead body here, tomorrow there may be questions put to us. There may be police investigation. So in that way, they just remove the dead body of the who has died otherwise, not of homicidal death, to that place and threw the dead body, which was detected after 4 to 5 days. So question is that there must be evidence that an offense has been committed. So suppose somebody has died a natural death, because you are not proving that it's a case of unnatural death or it's a homicidal. So if that is not there, if an offense is not committed, and knowing that the offense has been committed, they must try to cause disappearance of the evidence. Then only 201 would be accepted.
Here 201 is not sustainable, my lord, that I also agree. But
removal of the dead body is all right. I can say you are right that whatever evidence is there, let us say no importance is to be attached to the delay in lodging of the FIR, that entire prosecution case is to be discarded. That is not due. Removal of the dead body has been proved, but merely because the dead body is removed from one place to another, 201 would not be accepted, because it further requires that an offense would be committed the person who is removing the body or causing, he must have the knowledge that the offense has been committed, and to screen the offenders, he is doing that. Then only can the 201 go. Otherwise,
But my lord, reading PW 1, 2, and 4, my lord, there was a ill feeling. Admittedly, there was a ill feeling between them.
right?
There was no report was filed by this appellant, my lord. When his son is out of for last 4-5 days, they have not filed any missing reports.
Yes.
That too, after 2 or 3 days, when the uncle of the PW2, the uncle of the informant, going through that area, that place, the appellant number 2 has stated that he has gone for a puja. And thereafter, my lord, when the dead body was found, from that place they absconded, my lord. And thereafter, last scene, they were seen last scene
By
there,
PW1.
PW1. And affidavit was filed, which was a DW1. They have introduced that evidence. So seeing this, all these things, my lord, a doubt is coming. They might have killed him.
So again,
Even if the homicidal death is not there. So I pray, well,
no, might have killed, that offense he
Yes.
has been acquitted, state has not
acquitted.
charged.
Yes, but
So
not
state has, that part is closed, chapter is
Yes.
closed. Now
201, this is not
201.
coming. So I pray, well, it will let me to be remanded at least, my lord.
No, it's a 2000 matter. Are the learned counsel for the the appellant, the appellant. अरे तमे परा नेइथिलो डिक्टेशन रे फास्ट जजमेंट रो की निकला अच्छा then you
To
take
that 201, my lord, that I am giving that only the reference. I am not citing this. Ramsaran Mahato versus State of Bihar. AIR 1999 Supreme Court 34.
Ramsaran Mahato
my lord, versus State of Bihar. AIR 1999 Supreme Court page 3435.
1999
My lord. I am not referring this matter because
Supreme Court
334 3435.
3435. What it says about?
In that case, that has been said that if there are 2-3 accused and one has been convicted in 302, then 201 is maintained.
All right. This is criminal appeal number 30 of 2001. The three appellants, Padavendra Senapati, Kausalya Senapati, and Soros Senapati, faced trial in the Court of Law and Session Judge, Baleswar Bhadrak, Baleswar, in ST case number 53 of 1999 for offences punishable under section 302, 201 by 34, read with section 34 of the Indian Penal Code. On the accusation that on 26/2/1997 at Belbaria, they committed murder of Manoj Senapati, alias Sambhu Senapati, hereafter the deceased, in furtherance of their common intention. And knowing that certain offense has been committed, which is punishable with death or imprisonment for life, they cause certain evidence of the said offense to disappear by throwing away the dead body with an intention of screening themselves from legal punishment. The London Trial Court, by judgment and order dated 16 December 2000, acquitted the appellants of the charge under section 302 of the Indian Penal Code. However, found them guilty under section 201 of the Indian Penal Code and sentenced each of them to undergo rigorous imprisonment for a period of 1 year. The dead body of the deceased, the prosecution case, next para. In short is that the dead body of the deceased was recovered from a paddy field called inverted comma bhitere Mahabilan Nola. And the UD case was instituted and who is the person who inquired into that UD case? He has been examined.
Yes, Lord.
PW?
6. PW 8, Lord. Page 104 of the paper, Lord.
Was instituted on 2/3/1997 by the Jaleswar PS UD case number 5 of 1997 on the written report presented by Gaurahari Das, OIC Jaleswar Police Station. And PW 8 Surendra Kumar Behuria, Sub-Inspector of Police Jaleswar Police Station, was directed to take off inquiry of the said UD case. During course of inquiry, PW 8 examined the witnesses, visited spot, prepared inquest report over the dead body of the deceased, seized the one check lungi from the spot, sent the dead body for postmortem examination, and received the PM examination report subsequently. On 16/3/1997, PW1 Srimati Swapna Rani Senapati, the widow of the deceased, lodged the first information report before Jaleswar Police Station, on the basis of which Jaleswar PS case number 26 dated 16/3/1997 was registered under section 302(201) by 34 of the Indian Penal Code against the appellants, wherein it is stated that the deceased was a jobless person for which the appellants, being the father, mother, and brother of the deceased, were assaulting him and on the date of occurrence, the deceased was present in the house, and when he felt hungry, he came to the kitchen but found it was locked, and accordingly he broke open the lock, entered inside the kitchen, and took the food, for which his mother, Kausalya Senapati, appellant number 2, threatened her with dire consequences. Such an incident took place at 9 o'clock in the morning, whereafter the informant went to the cultivable land and returned in the evening hours and found the deceased was absent. And the room of the deceased was also locked. When the informant asked her mother-in-law about the whereabouts of the deceased, she told that the deceased had gone to the village. And after taking food, the informant went to sleep, and her mother-in-law slept guarding the entrance of the room where the informant was sleeping. In the night, the informant got up and found her father-in-law and brother-in-law were removing the body of the deceased. And when the informant started crying, she was threatened by the appellants with dire consequences, and also not to disclose the same before others. Out of fear, the informant didn't disclose before anyone. Stop. Subsequently, when the dead body was of her husband was found, she identified the same but remained silent and did not complain before anybody on account of fears. She came to reside in her father's place and ultimately getting assurance from the paternal side family members, also the villagers, she lost the affair. Who is the IO of the case?
FIR was registered by PW6 Lordship. After someday PW7 took charge from PW6 also.
The PW7, the Circular Inspector of Jaleswar, took charge of the investigation from PW6. Who had registered the FIR and started investigation of the case. PW7 made a query to the doctor who conducted postmortem examination, received the query report, so also the postmortem examination report. On completion of investigation, submitted charge sheet. In order to prove its case, the prosecution examined so and so witnesses. The London trial court, after analyzing the evidence on record, came to hold that the prosecution has not been able to prove the death of the deceased was homicidal through the doctor or through any other piece of evidence. And PW1, although has stated to have seen the dead body of the deceased having been carried by the appellants, has not seen the alleged killing of the deceased, and therefore it could not be pinpointedly concluded that the death of the deceased was homicidal. However, the London trial court, taking into account the evidence on record, the behavior of the appellants on the date of occurrence, as per the evidence of PW1, the recovery of the dead body from the paddy field, which was duly identified to be that of the deceased, came to hold that the appellants tried their best for disappearance of evidence with regard to the suspicious unnatural death of the deceased, intending to screen themselves from legal punishment. Accordingly, held them guilty under section 201 of the Indian Penal Code. Mr. Siddharth Shankar Lenka, the London Council, appearing for the appellants, contended that when the appellants have been acquitted under section 302 of the Indian Penal Code, and the finding of the London trial court is that the prosecution has failed to establish that the deceased met a homicidal death, merely because on the basis of evidence of PW1, it is established, it appears that the dead body was removed from the house of the appellants, it cannot attract the ingredients of the offense under section 201 of the Indian Penal Code. The London Council further argued that the occurrence in question stated to have taken place on 26 to 1997. 4 to 5 days thereafter, the dead body was recovered, and thereafter, UD case was instituted and police was investigating the matter. And the evidence further appears that that PW1 went to stay at her father's place. And in such a situation, had there been any knowledge available with PW1 regarding to the commission of the crime by the appellants, she would have immediately disclosed the same before her family members, the villagers, and also to the police. And in view of the belated lodging of the first information report, it can be said that the case has been concocted at a to falsely implicate the appellants. And since there is no other cogent evidence on record, it's a fit case where the benefit of doubt should be extended in favor of the appellants. Mr. Rajesh Tripathi, London Additional Standing Counsel, on the other hand, submitted that even though the appellants have been acquitted under Section 302 of the Indian Penal Code, there is no bar in convicting the appellants under Section 201 of the Indian Penal Code, particularly when, in view of the evidence of PW1, it is apparent that in the dead hour of the night, the appellants removed the body of the deceased from the house, and they also did not lodge any missing report before the police station, and there was ill feeling between the appellants and the deceased, and the deceased was not working and sitting idle in the house. And moreover, the appellants absconded, and all these circumstances create strong suspicions that on the occurrence night, they removed the dead body from the house for causing disappearance of the evidence, and therefore the London Trial Court has rightly found the appellants guilty under Section 201 of the Indian Penal Code. The question that crops up for consideration, whether after acquittal of the appellants under Section 302 of the Indian Penal Code, conviction under Section 201 of the IPC can be sustainable in the eye of law or not. এইটা আসলে ঠিক আছে। In the case of Sukram versus State of Maharashtra, reported in 2007, Volume 7, Supreme Court Cases 502. Relying on the Constitution Bench decision in Kalavati versus State of Himachal Pradesh, reported in AIR 1953, Supreme Court 131. it was held that it is well settled that notwithstanding acquittal of the accused of the offense under section 302 IPC, his conviction under section 201 of the IPC is still permissible. Subpara. To bring home an offense under section 201 IPC, the prosecution is required to establish the following ingredients. 1. Committal of an offense. 2. Person charged with the offense under section 201 must have knowledge or reason to believe that an offense has been committed. 3. Person charged with the said offense should have caused disappearance of evidence. And 4. The act should have been done with the intention of screening the offender from legal punishment, or with that intention he should have given information respecting the offense, which he knew or believed to be false. It is plain that the intent to screen the offender committing an offense must be the primary and sole aim of the accused. It hardly needs any emphasis that in order to bring home an offense under section 201 IPC, a mere suspicion is not sufficient. There must be on record cogent evidence to prove that the accused knew or had information sufficient to lead him to believe that the offense had been committed and that the accused had caused the evidence to disappear in order to screen the offender from unknown or unknown. In the case in hand, with the doctor who conducted postmortem examination,
PW5 also.
the doctor bracketed PW5 who conducted postmortem examination over the dead body of the deceased has stated that the body was in advanced stage of decomposition, face and limbs mutilated and partly eaten away by the wild animals. Bones, teeth, limbs were exposed, and the body was full of maggots and abdomen distended, and both the legs were eaten away up to the level of the ankle. Left palm was absent up to the wrist. On dissection, he found no intestine was descended, stomach was filled with undigested food, and since the body was highly decomposed, no external injury could be marked. With regard to the cause of death, the opinion was reserved pending chemical analysis of viscera, and viscera report was obtained.
No, not exhibited.
Yes, Mr. Tripathi. It appears that no viscera report was obtained and produced before PW5 to obtain the final opinion regarding the cause of death of the deceased. Therefore, there is no evidence on record that the deceased met with a homicidal death or any unnatural death. And that is how the Lennon trial court has arrived at the finding that it cannot be pinpointedly concluded that the death of the deceased was homicidal. No doubt, from the evidence of PW1, it appears that she had seen the removal of the dead body of her husband, deceased, from the house by her father-in-law, appellant number 1, and mother-in-law, brother-in-law, PW3, and she was also threatened. But unless there is evidence that it was a case of homicidal death, or that an offense has been committed and the appellants removed the dead body from their house for causing disappearance of the evidence, the ingredients of the offense under section 201 of the Indian Penal Code would not be attracted. Offense has been defined under section 40 of the Indian Penal Code. Therefore, I am of the view that there is no material before this court to show that the appellants had the knowledge that an offense has been committed, or at least they had reasons to believe it, and knowing or reason to believe they caused the disappearance of evidence of commission of that offense. Stop. No doubt the Lenin counsel for the appellant advanced his argument regarding delay of lodging the first information report, and it appears in this case the FIR was lodged almost 18 days after the date of commission of the offense, but the state of mind of the PW1 and the threat stated to have been given by the appellant to the deceased, to PW1, cannot be lost sight of. More particularly, the evidence of PW1 also indicates that she was frightened, for which she lost the balance of mind. And out the Bappa Ghar evidence kete,
PW4, father of the informant.
and PW2 has stated,
PW2 is the uncle.
PW2 has also stated.
PW2 the uncle of the
Informant.
has stated. Cool line ta dekhe na.
Page 84, your lords.
Cool line.
Fourth line, your lords.
That PW1 was always crying in her parents' house and was becoming senseless at time. And similarly, PW4 has stated, PW4, the father of the informant, has stated that for 15 to 16 days, she was unable to tell anything out of shock as she lost her balance of mind. Therefore, in my humble view, delay cannot be the sole factor to disbelieve the evidence of PW1. However, the submission of the Learned Council for the state that there was ill feeling between the parties as the deceased was not doing anything. Is no doubt appears from the evidence of PW1. But it is very difficult that over this issue, the parents of deceased and brother would go to the extent of killing him. Therefore, the motive behind the commission of the crime is also absent in this case. Though the appellants were found absconding, but law is well settled that absconding itself cannot be a factor to prove the culpability of the accused persons. In view of the foregoing discussions, when the prosecution has not satisfactorily proved the death of the deceased to be homicidal in nature, and has also failed to prove that the appellants had knowledge or reason to believe that an offense has been committed, merely because they were found removing the dead body from the house in question, it cannot be said that the ingredients of the offense under section 201 of the Indian Penal Code is satisfied. Therefore, the appellants are acquitted of the charge under section 201 of the Indian Penal Code. The criminal appeal is allowed. Put a note of appreciation on both the counsel. File the
Obliged, Lord.
Yes, Mr. Mishra.
Supplementary list item number 1.
Replacement. I invite your lordship's kind attention to the evidence of PW1, paragraph 110, at page 87 to 89. Hmm? 87 bottom.
But placed, I think, yesterday.
87.
গতকালি প্লেস করছিলেন না গো?
109 ଯାଇଥିଲେ। 110টা place।
No, you just place the relevant lines because entire
only relevant line. only relevant line. It is a fact that I have mentioned in my election petition in paragraph 7a in page 7, eighth line from the top, that the respondent Shiomoto deleted part 2 of form 2b in the nomination paper. Filed by him before the returning officer on 2/4/2019. It's a fact that instruction is available in the nomination paper in form 2b to strike off part 1 or part 2 below, whichever is not applicable. Part 1 is to be used by the candidate set up by the recognized political party. I have struck off part 2 in my nomination paper in form 2b as part 2 of the nomination paper in form 2b was not relevant for a candidate set up by a recognized political party. And since I have been set up by a recognized political party, I have struck off part 2. It's a fact that respondent Muhammad Mukim was a candidate set up by recognized political party, that is Indian National Congress. It's a fact that respondent Muhammad Mukim was also required to fill up part 1 of his nomination paper in form 2b. It's a fact that the downloaded copies of the nomination papers along with the affidavit in form 26 from the website of Election Commission of India have been filed by me, which are already marked as Exhibit 1, 2, 3, 4, as well as Exhibits 32, 33, 34, 35. I have not raised any objection during scrutiny of nomination papers before the returning officer that the respective proposers of the nomination papers of the respondent were not the electors of 90 Baravati Kotak Assembly constituency. I have also not raised any objection during scrutiny of nomination paper before the returning officer that the nomination papers filed by the respondent in form 2b were not in prescribed form 2b. After the result of election, it came to my knowledge that the nomination papers filed by the respondent was not in the prescribed form 2b and that he Shiomoto deleted part 2 of the form 2b. It's a fact that it came to my knowledge after 23/5/2019 and before 3/7/2019. I cannot say whether I have taken any averment in my election petition that it came to my knowledge after 23/5/2019 and before 3/7/2019, and I also cannot say whether I have given any proof in my election petition to substantiate such an aspect.
Yes.
So there were two scopes before him. One, to object it before the returning officer on the date of scrutiny.
That he has not done.
That he has not done.
According to him, he had no knowledge.
According to him, ସେଇଟା ବି ସେ ପ୍ଲିଡ୍ କରିନାହାନ୍ତି ମୋର ନଲେଜ ମୁଁ ଏତିକି ପରେ ଏବଂ ଏତିକି ପୂର୍ବରୁ ଜାଣିଲି ଏଇ ଫ୍ୟାକ୍ଟଟା ତାଙ୍କର ପ୍ଲିଡିଂରେ ଆବସେଣ୍ଟ। Though his representative advocates were present on the date of scrutiny. ଟିକେ ଏଇଟା kindly note.
Note କରିଛି ନା?
Mine.
Amitabh.
Mine.
Wasim Amitabh. Yes.
My advocate can say whether in the I
have noted down.
Yes, ma'am. My advocate can say whether in the pleading of my election petition I have mentioned that a candidate set up by the recognized political party is to fill up part 1 in the nomination paper in form 2b and that instruction has been given specially in the nomination paper in form 2b to strike off part 1 or part 2, whichever is not applicable. ଏଇଟା ତାଙ୍କ ପ୍ଲିଡିଂ ରେ ନାହିଁ, କିନ୍ତୁ ପଚାରିଲା ପରେ ତାଙ୍କ ଏକ୍ସାମିନେସନ ଇନ୍ ଚିଫ୍ ରେ ବି ନାହିଁ, ଏଭିଡେନ୍ସ ଅନ୍ ଆଫିଡେଭିଟ୍ ରେ ନାହିଁ, କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ସେ ଏଇ କଥାଟା କହୁଛନ୍ତି।
But all the same, Mr. Mishra, what I suppose there was no objection, let us say, at the time of scrutiny. And thereafter, till the election petition was filed, there was nothing. But if it appears to the court
that I have
that,
already explained,
the deletion was improper, it should have been struck off.
Yes.
This court can take into account.
Yes.
Okay.
Take it
Merely because there was no objection was raised, that cannot be a ground that so yes.
Subject to section 36.
Right. Yeah.
Then paragraph 111. At page 90 and 91.
Yes.
In all the 4 sets of nomination papers filed by the respondent, White Exhibit 1, 2, 3, and 4, I find that it has been signed by the respondent at the appropriate places in Part 3 and Part 3A of Form 2B, and the respective proposers who have signed the nomination papers are the electors of 90 Baravati Kotak Assembly constituency, and therefore the nomination papers submitted by the respondent in Form 2B were as per law. Kindly make a note of this. Paragraph 111, there is admission that the nomination paper filed by the respondent, all the papers, where as per law. Therefore, his allegation that it is not in the prescribed form were given up. My submission is it was given up.
It can be said to be self-contradictory also.
Self-contradictory. Then it's a fact that Part 2 of the nomination papers in Form 2B is required to be used by a candidate who is not set up by any recognized political party and also by an independent candidate. It's a fact that 10 electors of the constituency are required to be the proposers for a candidate who is not set up by any recognized political party and also an independent candidate. The column has been provided in Part 2, Form 2B itself, where the particulars of the proposers and their signatures are to be given as per requirement. It's a fact that in Part 1 of the nomination paper in Form 2B, which is to be used by candidates set up by recognized political party, one proposer has to put his signature, and the particulars of the proposers as per the form are to be mentioned therein. Part 1. It's a fact that the respondent was not required to fill up Part 2 of the nomination paper in Form 2B, and the same is not relevant for the respondent. Kindly note this admission. Kindly come to page paragraph 112. a candidate cannot delete part 2 of Form 2B in the nomination paper filed by him if he is set up by a recognized political party. Only he has to strike up part 2 even if it is not relevant for him. Now I request your lordship to pause here for a moment. That he admits everything, but now it boils down to he should not have deleted it, only strike of it. ଗାର ପକେଇଥାନ୍ତେ, କାଟି ନଥାନ୍ତେ, delete କରିନଥାନ୍ତେ.
ବାକି relevant ନୁହେଁ ବୋଲି ସେ କହୁଛି.
ହଁ.
Part 2 is not relevant for
him.
He admits, and so there is no chance of question of feeling it.
Again.
So
Everything is admitted.
but one thing he says that it
Se
should have
Gaurav-
remained there.
Huh.
That part 2 should have remained there. You should have strike
Strike
it
up?
up, not deleted. That is
Whereas my case is
same
that
thing.
strike up and deletion
That
is
is
the
same.
same thing.
So once this court comes to a finding, it is same thing. So then matter goes that that chapter is closed.
That chapter is
Form
closed.
2B part 2 at least there is nothing.
My lord.
Okay, then
In my nomination paper as shown to me, I have struck up part 2 of Form 2B, whereas respondent has deleted part 2 in his nomination papers in Form 2B. I cannot say whether in the pleading of my election petition I have taken any averment that even though part 2 of the nomination paper in Form 2B is not relevant for a candidate set up by a recognized political party, he cannot delete the same, but he has only to strike off. What I say that this is beyond their pleading.
okay.
ତାଙ୍କୁ ପଚାରିଲା ପରେ ଏଇଟା କହୁଛନ୍ତି, ତେଣୁ ତାଙ୍କର କେସ୍ ମୋଟେ ନୁହଁ ଯାହା ସେ ଏଭିଡେନ୍ସରେ କହୁଛନ୍ତି. Paragraph 113. It's a fact that while mentioning in paragraph 7A of my election petition at page 7, 10th line from the top, that the part 3 of Form 2B of nomination paper filed the respondent is also not in the prescribed Form 2B. Is also not in the prescribed Form 2B. I have not mentioned in details as to why and how the same is not in the prescribed Form 2B. My counsel can only say about it. I request your lordship to pause here for a moment. Two things here it appears. First is respondent is also. Is refers nomination paper is singular. He alleges the defect to a single nomination. Therefore, it cannot be said all his 4 nomination papers suffers the same defect. Second aspect is he has not in his pleading stated that as to I have not mentioned in detail as to why and how the same is not in the prescribed Form 2B. Kindly noted.
No, the and
both ways.
If it is nomination paper, and he has not stated which of the 4
nomination
which one, then
ସେ ଗୋଟେ aspect.
That is, and in the court he has said that the nomination papers. All. So that right.
My second limb of contention before your lordship to this aspect is that this aspect doesn't find place in the pleading,
That's what
in the evidence on affidavit, examination in chief, as to why and how. It is different. The same is not in prescribed form.
He could have, what you mean to say that he could have stated that since he has omitted or deleted part 2, that is why I have said that it was not in one of the grounds for not stating. But he has not stated like that.
No.
Part 3, but part 2 के थोड़ा part 2 टा सरीला 112 paragraph.
part 3 ଉପରେ କହୁନାହାନ୍ତି ଯେ as to why and how.
हाँ से कोई पारथांत एटी जैसे सेकंड लाइन टा जेतु लेखिना
डबल आई टा नहीं नेक्स्ट पार्ट 3 ए रा गया.
हाँ अब एटा को
पार्ट 3
A B C D E
पार्ट 3
part 3 टा
आज्ञा
सेटा होची 3A
सेटा 3A
এটা পার্ট 3 ର কলম সি ডবল আই টা ডিলিট ହେଇଛି
और delete ହେଇଛି
ଜାତି କଥାଟା
same ଜିନିଷ like part 2 and part 3 which has been totally deleted. You should have said I have said it is not in proper form because it instead of striking it has been totally deleted. Right. Okay.
Then rather ଆମ cross examination ଆମେ ଗୋଟି ଗୋଟି ସାର୍ ପଚାରୁଛନ୍ତି ତାପରେ କହିଛନ୍ତି.
Okay.
It's a fact that I have also not mentioned in paragraph 7A of my election petition as to what are the required informations to be given by a candidate in his nomination paper in part 3 of form 2B, which has not been furnished by the respondent. My counsels can only say about the same. He always depended on the statement or evidence of his counsels.
Part 3 ରେ କଣ କଣ ଇନଫରମେସନ ଦରକାର ସେ ଦେଇ ନାହାନ୍ତି ସେଟା ସେ ମେନସନ କରିନାହାନ୍ତି ବୋଲି ନିଜେ ମାନୁଛନ୍ତି.
Okay.
My nomination papers marked as exhibit E by 2, F by 2, G by 3 and H by 3 are all in the prescribed form 2B as per rules. I have given my assent to the nomination in part 3 of the nomination paper in form 2B. I have gone through part 3 of nomination paper in form 2B filed by respondent and I find that the same is not in the prescribed form and whatever columns are required to be struck off by the candidate has not been done, but the respondent has deleted the same in part 3. Question. Whether the respondent has given his assent to the nomination paper in part 3 in his nomination paper in form 2B. तापर आम तो गोटी गोटी की पचार से गोटी गोटी की सब हाँ कहते. Answer. Though in part 3 of nomination paper I find the respondent has given his assent to the nomination, but that is not in the prescribed forms. I invite your lordship's kind attention to the exhibit itself. Exhibit 39.
39 टा वर्क ए पार्ट 3 टा को जंदी
आज्ञा से जो assent portion टा से कहउचंदी it is not in prescribed form.
39 36 एटी गला ऊपर अछि बा नहीं तो
पाइले ना
yes part 3 तो
आज्ञा part 3 रो assent portion को छाड़ दा.
First line टा
part candidate देखा जाऊनी
हाँ 40 टा देखि दियंतु भाई
हाँ 40 हाँ
हाँ,
सीधा
40 टा
क्लियर
देखि
आसनी 40 टा देखी एका तो
आगे
ଆଜ୍ଞା
हाँ हाँ एटा क्लियर अछि हाँ
I the candidate mentioned in part 1 assent to this nomination
ହୁଁ
ତାଙ୍କର ମଧ୍ୟ ଦେଖନ୍ତୁ ଏକ୍ଜିବିଟ ଇ ବାଇ ସି ଯୋଉଟା ହେଇଛି
ହୁଁ
ଇ ବାଇ 2 ହେଇଛି ତାଙ୍କର ମଧ୍ୟ ସେଇ ଲାଇନଟା ସେଇଆ ପ୍ରପୋଜ୍ଡ
ଏଟା ତ ଫର୍ମାଟ ଟା ଆଉ କଣ
ଆଜ୍ଞା
ଖାଲି
ସେ
ପାର୍ଟି
କହୁଛନ୍ତି not in a prescribed form, but I beg to impress upon your lordship that it is in a prescribed form. Dotted line.
ଖାଲି ସେଇ ଡଟ୍ ଜାଗାରେ ଇଣ୍ଡିଆନ ନ୍ୟାସନାଲ କଂଗ୍ରେସ ଇଏ ପୂରଣ କରିଛନ୍ତି ସିଏ ବୋଧେ ବିଜୁ ଜନତା ଦଳ
ବିଜୁ
ପୁରେଇଥିଲେ
ଜନତା ଦଳ କରିଛନ୍ତି ଆଉ
ଆଉ ତ ସବୁ ସମାନ
ସେଟା ସି କୁ ଆସିଲେ
ହଁ
ସେଟା
ହଁ ସି ରେ ହଁ yes
ତାପରେ
next
in part 3 of form 2b under item A, I find that it has been correctly done. He admits it.
ସେଟା ବାହାର କରୁଛି ଏଭିଡେନ୍ସ
100
ଶହେ କେତେ ଗୋଟେ
ସେଟା ହଉଛି 192 ନମ୍ବର ପେଜ ଅଛି
100 କେତେ ପଢୁଥିଲେ
92 page
92 हाँ सेटा बाहर
last
yes
but one so far.
yes got it yes continue
It has been correctly done.
Part 3.
In part 3 of form 2b under item A, I find that it has been correctly done in the nomination paper of respondent, wherein he has declared that he is a citizen of India and has not acquired the citizenship of any foreign state.
yes
ଏଟା correct ଅଛି
So, ସେ ମାନୁଛନ୍ତି ଯେ ଏଟା correct ଅଛି.
then B
Then in part 3 of form 2b under item B, I find that it has been correctly done. In the nomination paper of respondent, wherein he has declared that he has completed 53 years of age. 25 ବର୍ଷ ହେବା କଥା ସେ 53 ବର୍ଷ ବୋଲି ତାଙ୍କ ବୟସ କହୁଛି. Before item number C in part 3 form 2b, there is instruction to strike off CI or CII below, whichever is not applicable. It is a fact that in item number CI, a candidate has to declare that he has been set up in the election by the particular recognized political party, either national or state, and to further declare that the symbol referred for the said party be allotted to him. I have mentioned Biju Janata Dal in gap portion in item CI. The respondent has mentioned Indian National Congress in the gap portion in item I. CI. I have struck off CII in part 3 as it was not applicable to me, being a candidate of recognized state political party. The same is also
yes
same with respect to the respondent. There is no such item as a CII in part 3 in the nomination paper of the respondent, and he has totally deleted the same and changed the format of the prescribed nomination paper. According to me, item D in part 3 of the nomination paper of the respondent is not in the prescribed format, as the respondent has deleted name of the language. It is a fact that so far as item E in part 3 of the nomination paper it is a fact that so far as item E in part 3 of the nomination paper of the respondent is concerned, there is no deletion.
so once a particular paragraph is not relevant a candidate, whether he deletes it or strikes
it off,
it becomes immaterial.
immaterial. That is my submission.
That is not a defect of substance.
That is not at all a defect. Then kindly come to paragraph 114 at page 93 to 94.
93 bottom to starting.
Fine.
114.
90 Baravati Kotak Assembly constituency is declared as general constituency, which is not reserved for SC/ST candidates. In my nomination paper in part 3, I have scored out in paragraph. I have scored out the paragraph. I further declare that I am a member of the dash dash caste tribe, which is a scheduled caste tribe of the state dash in relation to dash area in that state. In part 3 at the end, instruction has been given by putting 1 star to score out this paragraph if not applicable, and 2 stars score out the words not applicable. I invite your lordship's kind attention to chapter 2, qualification for membership of a state legislature, section 5. Qualification for membership of a state legislative assembly.
Section 5 clause.
RP Act, though.
RP Act.
Yeah. Which section?
5. Clause A.
Yes.
In the case of a seat reserved, মানে qualification সেটা পাইলে না, a person shall not be qualified. সেটিকে গারমার। এটা হলা not qualified. A person shall not be qualified to be chosen to fill a seat in this legislative assembly of a state unless A. In the case of a seat reserved for the scheduled caste or for the scheduled tribe of that state, he is a member of any of those castes or of those tribes, as the case may be, and is an elector for any assembly.
এটা কাই প্লেস করছেনদি? This is not the issue here. It's a just relevant portion place করুন. This is not just don't kill the time of the court. I am to give the judgment, so try to finish it.
Don't place irrelevant.
Yes. Don't unnecessarily think.
10 ଥର କହୁଛି କରିବା ନା ଆପଣ କହୁଛନ୍ତି କହନା ତ
33 2 ଟା ବୋଧେ.
Yes.
Informed to be, this paragraph has been totally deleted, which should not have been done, and by doing so, the respondent has changed the format.
Yes.
এইটা কହୁଛି ଯେ ଯୋଉଠି ଏଇଟା ରିଜର୍ଭ ପାଇଁ ଥିବ ଡିକ୍ଲାରେସନ କଣ୍ଟେନ୍ କରୁଥିବ
Section 33 subsection 2 टा clearly କହୁଛି ଆଜ୍ଞା unless his nomination paper contains a declaration by him specifying the particular caste or tribe. 33 2 ଟା ଦେଖିଲେ ଜାଣିବେ।
Okay. According to the him, that by deleting form to be,
format ଟା change
that format is changed. Okay,
But
that is
section
the code is to be
33 section 33 subsection 2 କହୁଛି कि in a constituency where a seat is reserved, a candidate shall not be deemed to be qualified to be chosen to fill that seat.
This is not a reserve constituency. 90 Baravati is not a reserve constituency. That question doesn't arise here. Only that whether it changes the format or not, that is to be seen. Yes.
My lord.
Carry forward. Carry forward. Yes.
Then, my lord,
you see, when cross-examining the witnesses, many things are put to the, that doesn't mean that while arguing every paragraph.
ନାଇଁ ନାଇଁ ଆମେ ସେମିତି କରିବାନି ସେଟା ଠିକ ବି ନୁହଁ।
Yes.
It's a fact that your lordship got that.
Yes, yes.
That it's a fact that in the last declaration in part 3 of the form 2B, wherein the candidate is required to declare that he has not been and shall not be nominated as a candidate at the general election by election being held simultaneously to the Legislative Assembly of the state from more than 2 assembly constituencies, there is no declaration in the no deletion of the format of the respondent.
Yes.
It's a fact that in the end of part 3 of form 2B, like me, the respondent has put his signature and also the date, and is not a fact that the nomination paper filed by the respondent in form 2B is a correct one and as per prescribed format.
Yeah.
Lord, ତାପରଠୁ ଯୋଉଗୁଡାକ 3A କୁ contain କରୁଛି। I suggest it to go it tomorrow. Paragraph 115 ଟା ଟିକେ ଦେଖିଦିଅ। That only relates to 3A.
All right, we'll take up tomorrow. Tomorrow, 3 o'clock.
So far as this ruby is concerned,
No, the Mr. Kanungo, I am giving liberty because this particular it covers almost 12 to 13 issues.
yes, sir.
That is why otherwise and
No issue should be left.
No, I'm not saying that.
Every issue they have a right to answer.
Certainly.
And you have also
You have a right to,
and I have also given a finding.
Yes, sir.
That issues have been framed, and if I do not leave it as such, then that would be not proper.
appropriate.
We have devoted so many hours.
That is why I'm telling, and both of you have cooperated. If I do not deliver the judgment, you see, nobody would excuse us, neither as a counsel to you nor as a judge to me.
Exactly.
Nobody would excuse us. So much of time has been spent. I would have disposed of thousands of cases. So, so that is, please take into account. Just please cooperate, and that is you have assured me. So, in that way, please cooperate till you have already cooperated. So try to finish it as quick as possible.
My lord.
Give me breathing time so that I can prepare the judgment.
My lord.
Otherwise, it would be just killing the valuable time. Just
That is my entire anxiety. Whether I win or win.